Good evening. I'm Michael O'Reilly, the chairman of the Town of Monroe Planning and Zoning Commission. It is January the 6th, 2022. It is 7:04 p.m. Please stand and join me in the Pledge of Allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Tonight, we're having a hybrid public meeting. This meeting will be recorded and made available on the town's website pursuant to state law. Written and public comments in compliance with the guidelines for public participation may be submitted up to the close of the business day of each meeting via electronic submission. I'm going to call the roll, starting on my right.
Dominic Smargalino, alternate.
Meet you, alternate.
Ryan Condon, secretary.
Leanne Ambrosi, commissioner.
Bruno Maini, vice chairman.
Robert Westland, commissioner.
Nicole Lupo, alternate.
Rick Schultz, town planner.
And
Recording secretary.
and I'd like to acknowledge the presence of Vin Marino, counsel for the Planning and Zoning Commission online. I think that's everyone. We have only one public hearing tonight. EFP 2021-03, 64 Cambridge Drive and 4 Independence Drive. Before we start that, is there anyone here from the public that would like to address the commission on matters not having to do with EFP 2021? Is there anyone online that would like to address the commission tonight on any matter not having to do with the public hearing tonight? Hearing none, then we'll go to the public hearing. Was that someone?
Yes, this is Barbara Thomas. I don't know if I should mention it now, but I did have a correction to the minutes for December 9th.
Yeah, that'll be later.
Okay.
We don't really do public then though, right?
I think we have, we have, that's on the agenda.
Yeah, that's under,
Okay, thank you. And then, all right, so we're going to reconvene the excavation and fill permit hearing. Rick, do we have any new exhibits?
yes, Mr. Chairman, we have exhibits that were presented by the intervener. And that is known as exhibits 10 and 11. And Kevin, I don't think you, and then, did you submit any additional exhibits?
We only provided a copy of the letter that was submitted to DEP with all of the information they had requested from the previous owner's activity. We provided commission a copy of that. I think that was back still in December, the 22nd, I believe.
That is correct.
Yeah.
And that concludes the new exhibits.
Okay, let's go to the applicant. This hearing over, I don't think there was anything for you, they didn't present to us that was requested, but go ahead.
There was not, no. At the last hearing, we kind of talked at length about, the latest information we had provided. We heard the commission loud and clear. We didn't want to introduce any new evidence into the record. We think the record speaks for itself, and we've provided sufficient information in that regard. Following up on some of the discussion at the last hearing, there was, as we had discussed at the last hearing, the DEP had requested some information regarding the previous owner's activity on the site. As I just mentioned, we provided that information was collected from the previous owner, submitted to DEP on December 22nd. We provided the commission a copy of the letter showing that we are continuing to work with them, and we gave them the requisite information they were looking for. I know the intervener provided a whole bunch of new information to the commission. I think at this point, we'd be happy to hear anything additional the intervener may have, and then we'd be looking forward to kind of giving our closing remarks and answering additional questions that the commission have, and hopefully push to this hearing.
Okay.
Thank you.
Thank you, Mr. Soley. Let's go to the intervener next. And then we'll go to the public.
Good evening.
Evening.
Good evening. Once again, Mr. Chairman, members of the commission, my name is Joel Green. I practice law in Bridgeport with the law offices of Green and Gross, and it's my pleasure to appear before you this evening on behalf of Peter Metropolis, as trustee. That stuff up here. I think so. We have, the intervener has submitted a variety of materials. We had submitted some clips from YouTube videos that were, we felt of this proceeding and of the previous proceeding before the commission in order to sort of provide the commission with some contrast to some of the information that's been provided in response to this application at present. I don't know, I guess the response I got was that those videos, the YouTube videos, are public record. However, there are some excerpts that I hope to play if the technology cooperates this evening. We'd like to submit that. We've also, my client had submitted some materials to the commission consisting of some photographs and some other documents that we felt that should be in the record. I will address those, and I expect perhaps that my client will as well. And most recently, this afternoon, I had presented to the commission some documents. And just by way of background, I apologize for providing documents just hours before the meeting. But as I explained in my email to the commission, the materials that I submitted today were delivered to me by a courier last evening. And just by way of a little bit of background, there is a letter that was, let me just go to it. There was a letter written by Attorney Warren to the Mark Jepson at Deep. That letter was dated December 22nd. Attorney Warren was good enough to email it to me on Thursday, last Thursday at 4:35 p.m. I had immediately emailed her and noted that there were several enclosures with the letter and attachments to the letter that had not been provided with the letter that I had received. I asked for copies of the enclosures. So the minute I got the letter, I asked for copies of those materials. I did not receive a response until Monday, and apparently Attorney Warren was on vacation. Apparently her office was closed due to COVID, but she declined to provide me with the enclosures and suggested that these were matters of public record and could be obtained from Deep. So my client and I both contacted Deep, and Mark Jepson was good enough to make those documents available yesterday at 3:30. And through a courier, I received them last evening and I submitted them today. So certainly there was no delay on our part. Many of the documents I think are of interest to the commission. I will touch on them briefly, although they will be available for the commission to take a look at. Significantly though, I do have to note that, for example, the documents that were submitted demonstrate that in the 2 months before the current owner took title to the property, and in fact ending just 2 days based on the materials that were provided, the site received over 1,500 loads of material from Stratford High School to the site. And that the last ticket or record of a ticket shows that the last load of material from Stratford High School was received on May 7th, I believe, of 2019, and that the closing occurred on May 9th, so immediately before that. So what I'd like to do is, as we had referenced, and I appreciate the commission's patience, I know that we have gone a long way. I know that the commission and all of us are eager to see this site remediated, and we are all eager to see this site remediated. But we disagree on how that is achieved, but most significantly, we disagree with the nature and extent of the disclosure of what has occurred on the site. And I know we've gone around and around on this, but I would like to highlight a few points this evening. So I continue to have, I'll begin by asking some questions. And I guess from sort of 10,000 feet, the activities that are proposed for the site, as I understand it, and I'm going to ask the applicant just a few questions, are obviously there is this, we appear before the commission, interestingly, tonight and over the past 2 months on this filling and grading permit. And apparently the activity that is proposed involves a certain regrading and filling of the site. And as I understand it, and I don't have the exact number at my fingertips, but there's approximately 300,000 cubic yards of material on site, potentially, including material in the ground, and there is some stockpiling of materials. And I look forward to the applicant correcting me on that number. But my first question for the applicant in terms of this, the sort of excavation and filling activity is any material from this date forward, is any material proposed to leave the site from here on out? Now, I recognize that there's been some testimony about rebar and some processing of materials, and I think that there was some discussion, and the answer was that we're going to treat rebar just like we treat rebar on all projects in Monroe. But I would just ask the applicant, through you, Mr. Chair, to specify what the specific materials are proposed that will leave the site going forward. In other words, will any earthen material leave the site? I know that there's been some discussion of disposing in rebar, but if we can get some detail from the applicant, I think it would be enlightening for the commission. So that's the first question I have as an interview.
If you'd like to go ahead with all the questions, I'm going to have them answer them when you're through.
I somehow think that some of those answers will be lost if we just stack the questions. And
We're keeping track of the questions, right?
I'm writing them down.
Yeah.
You got them all written down? I'm keeping track of them.
I'm writing down. I'm making a list.
well, and if I have a follow-up question to the response, then how does that?
I think it should be appropriate.
Okay. All right. So what I'd like to know is what material is proposed to be taken off the site? And what are the specific materials that would be taken off the site going forward? How will it be removed from the site? In other words, I presume that they're going to truck material out, but we'll get to more detail on that. And where is it conceived that any material leaving the site will go? Meaning, where would rebar and how would that be disposed of? And also, if there's any other materials leaving the site, would that happen? I note that the applicant is asking, as part of this application, for a waiver of the zoning regulations. As I indicated in earlier remarks to the commission, I don't believe that this commission can grant a waiver, but that is central to this application. And I'm happy to, if there's questions on my position on that, I'm happy to answer it, but I had gone through that previously. I don't believe that the law permits this commission to waive the regulations on a case-by-case basis. There is this concept in zoning of uniformity. Your regulations are applied equally to all property owners, and it is not this commission, but rather it's the Zoning Board of Appeals that grants variances or waivers from the zoning regulations. I would urge the commission to consult with the town attorney on that. I know that the town attorney and counsel for the town is familiar with the McKenzie decision and decisions like that. So I don't know that the intervener would submit that this commission cannot waive regulations on a case-by-case basis as the zoning regulations suggest. But if this commission is inclined to waive any of the zoning regulations, including the on-site processing of material that is brought from off-site. And I note that the applicant has talked about the fact that we're going to do this just like projects are done all over town. But that's not really true. What the applicant is proposing here that is different is this is not a situation where a building is being demolished on site or material is being excavated and crushed as stone or concrete. What the applicant is proposing here is to bring material from off-site and bring it onto the site. So foreign material, foreign solid waste as it's defined in the Connecticut General Statutes, and have it brought on site and processed on this site. Now, it is our position, the intervener's position, that that violates the Connecticut General Statutes and violates law because it is a solid waste treatment facility under the Connecticut General Statutes. I have heard the applicant's argument on clean fill and that sort of thing. And, I know we've gone around and around on that, but I would suggest that under the Connecticut General Statutes, it all comes under the heading of solid waste, and that the Connecticut General Statutes empower the DEEP to enact regulations and that sort of thing. But at the end of the day, it is the statutes that control, it is the statutes that control what DEEP can do in terms of how DEEP operates and how DEEP can adopt regulations and how DEEP can process applications and that sort of thing. And the Connecticut General Statutes would refer to this as a solid waste, as a processing facility, basically. So getting to that, you are being asked for a waiver. I've covered the fact that I don't think you should grant a waiver, but if you are inclined to grant a waiver here, you should understand the nature and the extent of the material that is going to be processed. So the question that I would ask this commission to ask of the applicant is, what is the specific material that is going to be processed? What's going to happen on the site? And I presume that the applicant is going to discuss the fact that there is stockpiled materials on the site. And the applicant is going to discuss the fact that there are materials buried in the site. And the applicant has indicated that they need to process, they use the phrase handle materials, but it's really processing it. They propose to bring a crusher to the site, and they propose to dig out material that's in the ground. And so you should get a description of what kind of materials, and I presume, but I think the applicant should answer this, that it's going to be asphalt, brick, concrete, and the like. And rebar, reinforced concrete that's reinforced with rebar that's going to come out of the ground. The applicant has also testified before this commission that there are stockpiles of that material. Now, before you grant a waiver, you should understand how much material we're talking about and how long that process will take. So this commission should ask, what is the scope? And the applicant has suggested that they've tested all the material, they know what all the material is, they know where it is, and so forth. And they've promised going forward that if they find anything, they'll deal with it. But before you grant that waiver, find out what the estimate is of the cubic yards of material that are going to be processed on the site. And I would divide it between material that is going to be excavated, and the engineer for the applicant has shown you that there are test holes in the region that's referred to as Stratford High School, that area, in response to questions by Commissioner Ambrosi. It was shown this area on the site and how much material out of the stockpile that's on the site is going to be processed on the site. so that you can understand what kind of an operation you are allowing to go forward on this site. There is a video I'd like to try to show you. And I'm not sure how to do this technically.
Excuse me, just a point of order. Is this a video of a part of the hearings previously?
Yes.
So I did send an objection to taking snippets of hearings before you, taking 1 or 2 or 3 minute snippets of hearings. I don't think that's proper. He's taking testimony out of context. As you all know, the hearings in this matter went on for hours, and at times later on, comments were clarified or amplified upon, and it's not appropriate for him to take a 1 or 2 minute snippet and present that as the God's truth to you about what the actual testimony was. If you're going to do that, you really have to listen to all the tapes all over again to be fair. So I object to this. I sent an objection on that basis as soon as I got these snippets. And I know Attorney Marino's on the line. He may overrule my objection, but I really have to object to taking, sort of taking piecemeal little items that he thinks proves his case without allowing you to hear all the testimony that may have been on that point throughout the course of the hearings. So I strongly object to this process.
May I respond, Mr. Chairman?
Yes.
I provided the complete video of the entire session, and I do start my video at the point that I want to present. And if Attorney Finn wants to show another section that he feels would be responsive, and by the way, I provided it to Mr. Finn, and Mr. Finn was at the hearing, so he has full access to all this information. And if there's something he wants to show the commission, I have no objection. The whole video is public record anyway. So I'm pointing.
Do you want to show it to us? If it's part of the public record, if we're part of the video, why do we need to see it?
Because I think it would be informative as to what the applicant is proposing here in terms of excavating that material.
Well, it's already in the record.
Right, we've already been through it.
Right.
Why are we going to rehash it?
see this again.
What's the sense of this?
Yeah, we don't need to see this again.
What's the commission's feeling on watching the video?
We've already been through it. I don't.
Well, I don't know if everybody's been through it. He hasn't been here. Right? When was the video? When?
Well, I have a few, but I have one from the.
Yeah, but at the end of the day.
What do you think on this end here? Do we need
I don't
to
need
see
to
the
see it.
videos?
Yeah.
No. All right, so let's skip the videos at this point. The commission's not interested in seeing the videos.
Plus Attorney Finn doesn't have adequate time to prepare a rebuttal to whatever we're going to see.
Oh, well, I had provided it to.
Well, technically, they gave it to him.
You gave the snippets?
Chair provided it to me yesterday.
On Tuesday.
All right, but we're
Why
not,
don't you just speak towards what is in the video?
Yeah, well, in the video, the engineer for the applicant points to an area of the site where there are test holes and says, this is Stratford High School. And there's an area where the test holes were dug and said, and in response to questions from Commissioner Ambrosi, he points to this large area of the site that has all of the buried Stratford High School waste in it. And says, we are going to dig this up and we are going to process it. And then on questioning from Commissioner.
I remember that.
And
I was here for that.
And they had a discussion about whether it was construction debris. And Commissioner Ambrosi submitted that it was construction debris, and Mr. Soley agreed with that, and that it was going to be processed on site and broken up, and that the rebar was going to be disposed of off the site. Then there was questioning about it.
We'll let them address that when it's their turn again.
Then there was a discussion at 53 minutes and 40 seconds of this video, which is a video from December 22nd, 2020, which was on the previous application. At 53 minutes and 40 seconds of that video on December 22nd, 2020, Mr. Soley says, in response to a question from Commissioner Ambrosi, said that there was no asphalt, that there was little or no asphalt in the ground that was buried on the site. And I can address that now if you'd like. If you refer to the WSP report, and the applicant keeps referring to the fact that there's, quote, no pollution on the site, and keep saying that the testing, characterizing what the WSP report, I'm referring to the subsurface and stockpile investigation report dated December of 2020. And if the commission, I don't know if you have that in front of you.
I have any of that.
That is,
Well, you can go ahead and read from it.
I think that was the report given to us last.
No, we're familiar.
No, we've had it
that
for a bit.
report.
so.
Go ahead.
All right, well, so on this, I have some short questions for Mr. Jones, who prepared the report for this. And I would refer the commission to Appendix 1 of that report.
Go ahead.
And in Appendix 1 of the report, and it would help me if Mr. Jones, and I think it would help the commission to understand the Appendix 1, which are these boring logs and what was found in the ground. And I don't know if Mr. Jones is available, but I think this is a question that in order to proceed with my presentation, I just have a question for him as to how this reporting was done.
Is Mr. Jones with us?
I believe Mr. Jones is on by Zoom. Mr. Chairman, I would like to raise another point of order. When we were here last, Mr. Green and Mr. Glass asked a slew of questions that we all answered. And when we adjourned last time, we adjourned because there were two submissions at the last hearing. A report by Dr. Derek Jones, which he had summarized but had not been handed in until the hearing, and a 40-page report from Mr. Glass that the commission wanted time to review. That was the only reason why we did not close the hearing the last time. So I object to the procedure where Mr. Green now is going backwards and trying to ask questions that he had the full opportunity to ask the last time. He's referring to a report that he had, that he could have asked questions. And now we're going back, and again, all with the goal of trying to drag this process out as long as possible, not to close the hearing again tonight. And with all respect, I don't think it's proper. He gets one opportunity. We get to rebut. If we submit more information, yes, he has an opportunity to ask questions on those new submissions. But he doesn't get to go back again to stuff that he could have raised at previous hearings. We're going to be here forever if this commission allows him to abuse the procedure of how these hearings should proceed.
Mr. Chairman, if I may.
Well, so far he's only been speaking for less than 30 minutes. And he's reviewing, so go ahead.
And I would have played a snippet of 8 minutes of the last hearing. After I spoke, the applicant, and as you may recall, Mr. Karp, Attorney Warren, and Mr. Soley were here answering questions, and that's what I'm getting at.
But you know, we're not here to determine if there's any pollution on the site. That's not our role.
I know.
So I
understand.
really want to go into technical details on your argument.
But this goes.
We're not prepared to even judge those findings.
I understand.
Beyond our purview.
I understand that.
So it does seem like you're just rehashing material that is irrelevant to this commission.
Well, here's why it's relevant. And I am not looking to establish pollution or not. What I'm looking to establish as a follow-up to that question about the waiver is the applicant had suggested that there is not asphalt in the ground there in the Stratford High School area of Philly. And I think that understanding these boring logs will help this commission to understand that there is a whole host of asphalt, brick, and concrete, and that the applicant has mischaracterized at times what's in the ground here. And and I think I just have a question for Mr. Jones as to how this reporting is done, because I think it It will help this.
Go ahead with your question. Is Mr. Jones here?
I am.
Okay, can you answer that one question?
Mr. Jones, my question is on your boring log. And I'm referring to, for example, boring number B1. We can start with the first one. I don't know if you have your report available in front of you.
Yep. Go ahead.
So when it refers to boring log 1, and at the bottom there's a chart and there's a description. So from 0 feet to 5 feet, it shows sand, and then it shows fine, and then it says little silt, brown, very dense, moist, trace asphalt. Can you just interpret for the commission when sand is all in capital letters in that, what is there a code as to why that is capitalized? And I note that in different entries, gravel is capitalized, concrete is capitalized. And can you explain to the commission what the code used on these boring logs is?
Right. It's the person who logged the boring. It's their primary determination of, the primary constituent, I should say, that their determination of what the primary constituent of the material they're looking at is.
So am I correct then that when it says sand in capital letters, that more than 50% of the constituent is made up of sand in that coring? More than 50% when it's capitalized is made up of sand?
Right. Yeah.
Okay. So similarly, from 15 feet to 20 feet in the ground at that in that boring sample, that 5 feet, more than 50% of that is concrete. 15 to 20 feet under the ground. There is that, and it's capitalized concrete.
Right. So if you look at the full thing, the full line, you're right, 15 to 20 feet of a macro core, the MC. Recovery is 1.5 foot. So likely they hit a piece of concrete. It's a 5 foot macro core. They hit a piece of concrete, and you only get in that macro core a sample of concrete of whatever obstructed the 5 foot boring log. Yes.
And then on the next page where it says from 30 to 35 feet, from 33.5 feet to 34 feet, it's red brick and concrete, some 32 feet under the surface. Is that correct?
Which one are we on?
30 to 35 feet on page 2 of boring B1.
So I have sand, red brick, and concrete, and then sand. Is that's what you see? Okay.
Right. And then going down 40 feet under the ground in that land, there's from 40 to 45 feet. So there's 6 inches of red brick, and that says wet. That means it's in the groundwater, doesn't it?
Yeah. Yeah. It's typically, yeah.
And then from 40.5 feet to 42.5 feet, there's 2 feet of asphalt in the groundwater. Is that correct?
45 to 40. Yeah. So of the recovery. Yep.
And then below that, there's gravel.
Yep.
And then when I look on some of these other pages, for example, when you look at boring log number 4, 15 to 20 feet in the ground, under the ground, is red brick and gravel, mostly 2-inch pieces, for example, in boring log 4.
Okay, is there a point to this?
Yeah, there's a point.
Go ahead.
The point is that there is a huge amount of brick. If you look at these boring logs, there are large amounts of asphalt buried. There are large amounts of concrete buried. And it seems to me the point is that before you start allowing this to go forward, the applicant has indicated that they plan to dig up this material and with the concrete to process it. And once again, this commission should understand how intense this operation is and what is being proposed.
Okay, well, let the applicant answer that question as
Okay,
well.
and when you read these boring logs, the capitalized term in these boring logs means that when they pull that coring up, more than 50% of it is that constituent. And I think we don't have to go through it, but
Thank you.
each one of these terms has a different percentage that's described to it.
Thank you. I like that, Mike.
I would like the commission to ask, with respect to this operation that is proposed, what permits have been obtained to date? And what permits have been obtained from the town of Monroe? Now, there is an indication in the application that there has been some sort of an approval of a restoration plan by the Wetlands Commission. And I just want to confirm that there are no other approvals that have been obtained from the town of Monroe. My understanding is that there are. I would like to know what permits have been obtained from DEEP or from any other authority of the state or the federal government with respect to this. I would like to know what future permits the applicant proposes to obtain with respect to the proposed activities from the town, and what future permits the applicant proposes to obtain from DEEP or from the federal government, from any agencies of the state or federal government. I would ask the commission to make inquiry of the applicant as to whether they are amenable to a condition where there would be a pre-application meeting with DEEP to review the proposal as a condition of approval by this commission, if this commission is inclined to do that. So I would ask this commission to do that. I will submit that I'm trying to figure out how to get in terms of the activities that are proposed. I think this commission should understand what the applicant is proposing in terms of the volume of material that will be brought to the site, trucked into the site. And this commission should understand the specific activity that is proposed by the applicant in terms of how the material is received. The applicant, I understand, has talked about this material intake protocol and this intake form. However, I think that the commission should also understand whether the applicant is is charging anyone to bring material to the site for use in the site, meaning is there a fee to receive material at the site? I would refer the commission to, and I would make inquiry of the town attorney in terms of the activities that are proposed. I would submit to the commission that there is not authority in your zoning regulations to allow a commercial facility in an industrial zone that is in the business of charging for the receipt of fill or materials or earthen materials, and that it constitutes a commercial business essentially. This is your filling and excavating permit application deals with an activity, it's not a use. And so the application is in the form of an excavation and filling permit, which allows this commission under certain conditions to grant the right to fill or excavate land. Here, the applicant, as I understand it, plans to set up a scale and plans to charge businesses to deposit material on the site, and is essentially conducting a commercial business in charging for the disposal of the various constituents that the applicant has described, including construction debris and material, I would suggest that the applicant would require to conduct an activity such as that, some sort of other permits from this town to conduct a commercial activity in an industrial zone, similar to you couldn't set up a store on that site and engage in retail or engage in business. And your regulations are obviously full of uses where folks come to you, where applicants come to you looking for special permits and that sort of thing to conduct businesses in certain zones. I would suggest that that commercial use is not one that is permitted in an industrial zone under any circumstances. I would also urge you to review with the town attorney the definitions in your regulations of junk and the definition of junkyard, and I can discuss that with you briefly. Basically, your regulations have definitions that I'm just going to need. Please bear with me. I would also note that the regulations, your regulations prohibit commercial quarries. And certainly this site became a commercial quarry after the exceedance. It started as a special permit to engage in an activity to develop the site. And obviously it morphed into something that went beyond that. But again, I would have I would consult your town attorney on those definitions in your regulations on those uses. Junk is defined in your regulations as any scrap, waste, reclaimable material, or debris. Registered, well, it talks about vehicles, and it specifically references construction and building materials in your regulations under junk. And junkyard is defined as any lot, land, parcel, or part thereof used for the temporary or permanent storage, collection, processing, purchase, sale, salvage, or disposal. And under your regulations, that activity is specifically prohibited. So what I'm getting at is, once again, to look carefully at what the applicant is proposing on the activities. I would suggest that while under certain circumstances, a filling and excavation permit might be appropriate, I think you've got to be careful about not turning it basically into a commercial business engaged in the business of receiving that material. And that's what the application looks like to me. So that would be, those would be important questions. So you don't want to see any videos?
Correct.
No.
I would urge the commission to ask the applicant to go through the documents that were submitted by the applicant that I submitted to the commission this afternoon that accompanied the letter to Mr. Jepson. And so that is reviewing once again the December 22nd letter. We would submit that the applicant still has not provided this commission with all of the information as to all the material that's gone into this site. At the last, I have a clip of Mr. Karp from last January addressing this commission and telling this commission that all of the documents or all of the material that has been brought into this site has been provided to the commission, has been provided to me. We have asked for it, and that is available. The commission gets to it. It's in the record, the clip. I would urge the commission to view the clip from December 22nd, 2020. So that's 12/22/20. And Mr. Karp speaks at 1 hour, 34 minutes and 52 seconds into the clip. And at that time, he submits that the applicant has made available and provided this commission, that the applicant has all of the documents and all of the documentation for all of the material that was brought into this site, both by Rockhead, both by these owners and by the previous owner, that all of those documents are in the possession of the applicant. And that was stated very specifically, and I think it's an important video for you to see, because at the last hearing, it was suggested by the applicant and applicant's counsel that they had made request of New England Materials to provide it, but they didn't have it yet. So in 1 year, everything has changed. And it's all in the video. And you can also see the video from December 22nd. And I don't have the specific time on that, but that was during this session when Commissioner Ambrosi was asking questions of, again, Mr. Soley, Attorney Warren, and Mr. Karp. And at that time, the applicant said they didn't have it, but they had requested it from New England Materials. I note that the materials that were provided to DEEP, some of them were actually prepared 2 weeks before our last hearing. So I think that they probably did have a lot of these materials, but the applicant can explain that. All right. So once again, I would ask the applicant to go through the letter and the enclosures that were submitted to DEEP. And specifically, the applicant goes through the Stratford High School, there's a list of the 1,500 plus truckloads of material. The applicant should be able to estimate how much Stratford High School material is in and provide this commission with some guidance as to how much excavation and processing is required. With the understanding that I can ask some follow-up questions after all of this is answered, I'll yield right now.
Okay. Thank you, Mr. Green.
Thank you.
We doing the public or are we? Now we'll let Sully speak.
Yeah, we'll let Sully.
Sully answers the questions. Yeah.
Okay.
And by 11 o'clock, we'll be home.
Thank you, Leanne. For the record, Kevin Soley, Soley Engineering, licensed professional engineer for Soley Engineering, offices here in Monroe. Thank you for Attorney Green and the questions. I'll run through and provide answers, but first I want to just clear up some misstatements that I believe were made. Attorney Green made some comments and alluded that there's material on the site that meets the definition of solid waste. And I'd like to read from the appendices of the State of Connecticut Solid Waste Management Plan on how solid waste is defined. Solid waste is defined as unwanted or discarded solid, liquid, semi-solid, or contained gaseous material, including but not limited to demolition debris, material burned or otherwise processed at a resources recovery facility or incinerator, material processed at a recycling facility, and sludges or other residue from a water pollution abatement facility, water supply treatment plant, or air pollution control facility. And references General Statute 22A-2073. Now, what was in that solid waste definition was demolition debris. I now want to read the definition of demolition debris from that same appendix. Construction and demolition waste. Construction demolition waste is defined as waste building materials and packaging resulting from construction, remodeling, repair, and demolition operation on houses, commercial buildings, and other structures, excluding asbestos, clean fill, as defined in regulations adopted under section 22A209, or solid waste containing greater than de minimis quantities as determined by the Commissioner of Environmental Protection of A, radioactive materials, B, hazardous waste, or C, liquid or semi-solid materials, including but not limited to adhesives, paints, coatings, etc. There is clean fill on the property. We are proposing to import clean fill to the property. We are not bringing solid waste to this property. Solid waste has not been brought to this property. The demolition debris has not been brought to this property. From day one, this applicant has been working and trying to develop a plan that avoids all those issues. And from day one, we've maintained what's demolition debris, what's clean fill, and what we're proposing to bring to this property. So the statements about solid waste and permits and things like that, they do not apply to what we are proposing. And I think I went through and I listened to those snippets of the record. I mean, that is our testimony. Our testimony is the record. So Mr. Green was submitting the record for the record. And he was, and I wanted to go back and figure out how many hours we have spent together discussing this application over the current application and the past application. I didn't have time to do it, but it's been a lot. I've probably spent more time on this particular project and definitely the site than any other project I've worked on in my entire career. But for Mr. Green to take a 3-minute section of a 4-hour video and try to say that because, you know, we may have referred to something as demolition debris, but other times we've called it clean fill, I think is disingenuous and it's misleading. And I'm happy to revisit and talk again about the same things we've talked about over and over and over again. But I think this commission has heard the testimony. I think the commission understands what we're proposing, despite the intervener's best efforts to try to paint a different picture of what's actually before you. To answer the specific questions, is any material proposed to leave? Yes, any deleterious material that's within the clean fill that's been brought to the site would be collected, put in a dumpster. A company would be hired to take that material off, and they would be responsible for the appropriate disposition of that material in accordance with every regulation that applies to the operation of their business. How will it be removed? It will be sorted. It'll be any deleterious material like rebar and things like that will be removed and segregated and put in a dumpster. So that's how it will be removed, using manifold methods of people actually being there, looking at it, grabbing it, moving it. Where will it go? It will go wherever the operators of those dumpsters take it. And it's going to be recycled in accordance with whatever regulations apply to those operations. The applicant is requesting waivers, and that's when he referenced solid waste. There's no solid waste here. We are not bringing solid waste in. There's no solid waste on the property, and there's been no evidence to contest that. We are requesting waivers in accordance with the regulations, which provide for an ability for the commission to grant those waivers. It's written directly into the text. And I think what's important that Mr. Green did not reference is that the McKenzie decision, which actually was done by this commission, was the commission in that case waived something that wasn't waivable. The regulations did not say you can waive this setback. In the excavation and filling permit regulations, it specifically says these conditions are waivable through request of the commission. So I believe that your regulations empower you to grant the waivers as we've requested. And I believe that's consistent with how this commission has handled previous applications of a similar nature. What is the specific material to be processed? The material to be processed is anything that needs to be crushed or graded to a specific gradation needed to place this material in structured engineered lifts. So when we're preparing a site to support a building in the future or a parking lot in the future, it needs to be placed in, a 12-inch lift, rolled with a compactor to make sure that it compresses enough so that it's going to be structurally sound. And that has to happen. what we've talked about at length, and I think, as we talked about at the last meeting, all the material that's been brought to the site needs to be handled in that manner. While the applicant has gone above and beyond, tested everything, we went through it all, and LEP has said there's no hazardous waste or contaminated materials on the site. Even if something was missed, which we don't believe it was, everything is gonna have to get handled. Everything is gonna have to get dug up and then placed in lifts. And during that process, if something is identified, it will be handled in accordance with all appropriate requirements and regulations. What permits have been gained to date? We have a permit from the Wetlands Commission to conduct the activity as shown on the plans in front of this commission. And those permits were pursued in accordance with a application prescribed by the Wetlands Commission in the exact manner in which they requested us to pursue that approval. We have the wetlands approval. We're now before this commissioner for an excavation and filling permit. From a state standpoint, we have a general permit for stormwater discharge from commercial activities for this property that's active and managed. And we have a general permit for stormwater discharge for industrial activities on this site with the DEP. Those are the permits that we have in hand. Those are the permits that we need from an operations standpoint. Those are the permits that we're going to continue to maintain. What future permits? As we've mentioned, there are going to be a lot of future permits on this property from both wetlands and planning and zoning, because any additional activity that takes place on the property needs to come back before you. So there will likely be many different future permits, because as we've maintained from the beginning, our goal is to fix a prior activity conducted by a previous owner. We're trying to take a property that has been scarred and make it productive again. We want to complete this activity so we have developable land where we can hopefully propose a 300,000 square foot distribution facility or something comparable, something that's going to add a tremendous amount of contributing tax base to the community. That's the goal. So we'll be pursuing additional permits associated with that. We've talked about DEEP. We believe we have all the permits required by DEEP. Will we attend a pre-app meeting with DEEP? No, because we don't need to attend a pre-app meeting with DEEP. We have all the permits that are required based on what we're proposing. And DEEP is very familiar with the site, actively working with the owner and the applicant to fully address all their concerns. And while the intervener is frustrated that they're not doing more, there's nothing more for them to do. And anything that they do, we will comply with everything that they request. The specific activities on the site, we've gone through this ad nauseum. We've talked about what we're going to do, how we're going to do it. It's in the record. It's on the plans. I don't want to belabor the point and drone on and on, because we've done that for days, for weeks, for months, for over a year at this point. So I think we've tried to do our best to develop a plan to fix a prior bad act conducted by a previous owner. And I think the record and the materials presented stand for themselves. Just a couple other housekeeping items before we, actually,
I'm gonna let the commissioners address you.
that'd be great.
See if you missed anything.
Sure.
That they're interested in.
Oh, yeah, there were some allusions made about material being buried and Stratford High School being buried. It's not buried. As we mentioned, it was imported to the property previous to the current applicant's ownership, and it needs to be gone through. It's essentially stockpiled on the site. It's not buried. The borings went all the way down through that pile to get to the natural ledge and bedrock underneath. And all the materials that he was up here talking about, brick fragments, concrete, stuff like that, it's clean fill. It's not solid waste. It's specifically listed in the definition of clean fill for DEEP. What constitutes clean fill? Every bit of material that he mentioned is clean fill. It's not solid waste. And we can keep trying to go round and round and say things in different ways to try to make people think differently about what we're proposing. It doesn't make the ghosts real. I think Attorney Fenn, do you have some thoughts?
Yes, just a couple of quick points. I want to talk just briefly about the McKenzie case and waivers. I actually thought Kevin did a pretty good job of distinguishing McKenzie from the first point, Kevin's 100% right. The special permit, the regulations in your zoning regulations did not allow you to waive. Your excavation and fill permit regulations do allow you to waive. And I want to give you a real world situation here, because excavation and fill permits are sometimes used to remediate over excavations, which is what we have here. The prior owner over excavated. In order to restore the property, you have to get close to the property line, and you may have to have different slopes. And if you didn't have the waiver provision, you would never allow somebody to be able to remediate an over excavation. So waivers are important, and they are perfectly applicable to an excavation and fill permit. So that's my first point. My second point is very, very brief. You know, we've heard about the interveners going on and on. He's repeated himself a lot. Many of the questions we heard tonight, and just about all the points we heard tonight, were already made, okay? But I want to just remind you, I'm not going to cite to a tape, but I think you're all going to remember. I believe it was Commissioner Condon who asked the intervener, Mr. Metropolis, at 2 hearings ago, what would you like to see happen to this property? What was his answer? I'd like to see it become a lake. Now, Attorney Green stood up and said, oh, they're eager to see the property remediated. Well, the intervener who hired Mr. Green, hired Mr. Glass, his whole goal, if you believe him, is to turn this property into a lake. Now, that's not to remediate or restore wetlands. So I submit to you that credibility is important here, and that the intervener, through all this stuff that they presented, does not have a lot of credibility. Kevin just did a good job of rebutting just about everything, that all the points that have been made. The test results rebut everything they've said. They try to contort it and say, well, you really didn't, you didn't go down into the ground. And here's the results. He spent some time with Derek Jones. Well, he didn't point out to you that those bore results were through stockpiles that were standing on top of the property, not down into past the stockpiles. So I submit that you're smart people, you're good at gauging credibility. In terms of, future permits, whatever permits are required, we're going to get. And if we don't get them, someone's going to be on our tail. So, thanks.
All right, let's go with the commissioners for questions for the applicant, starting on my right.
No questions, thank you.
Chairman, I hear that both the applicant and intervener are eager to remediate the site. They differ on how to approach it. What I'm hearing from the applicant, that he's willing to do whatever it takes to remediate the site. We also want to remediate the site. So help me understand what needs further to be done to remediate the site so that it's in accordance to what everybody wants.
Well, I mean, I'll just offer, this stemmed from a violation issued from the Wetlands Commission. We did an exhaustive analysis on trying to really understand exactly what the impacts were to the over excavation. And it was a reduction in watershed to the easterly wetland system. And we need to restore that watershed. In order to restore the watershed, we need to fill in the hole. We need to fill in the over excavation that was conducted. And that's exactly what this application proposes.
So whatever material was brought in that's inadequate to be there,
Will be removed.
you will remove it.
We don't believe there's any material on site that is inadequate to be there.
We don't know that.
Well, we do. Well, we are very confident that the material on site is good because it's been tested by an LEP.
Okay.
And we have records from the previous owner and all records of anything that's been brought in from under the current ownership. And that material meets the definition of clean fill and meets the definition, and it complies with it's in accordance with the material intake protocol that we've prepared as part of the site.
Would you, for us to be satisfied, I would like to see a professional that will answer to us on the material that's there and how it proceeds to be handled?
Well, I think the Wetlands Commission included a condition as part of their approval that that commission can engage an additional party to work on their behalf to provide inspections as needed. I think that's, this commission can certainly piggyback on that. I think the commission needs to be considerate of the overall amount of work and effort that's needed here. We've included in our application reporting that can come back to this commission. We're happy to come back and provide quarterly, biannual, whatever frequency the commission needs to see exactly what's going on, to hear what's going on, to see pictures, to understand it. I don't think that it's appropriate for the commission to create a condition that requires an independent third party 8 hours a day, 5 days a week. I think that's the team, the development team, the owner, the applicant, it's spelled out in the material intake protocol exactly what has to happen in order for material to be brought to the site. House has to be tested. I think the material that's been provided to DEEP and discussed with this commission actually reinforces that it works, because there is material that wanted to be brought to the site that's been rejected. So I think that the applicant shown that it works. And again, the owner, the applicant, has millions of reasons to want to make sure this site's clean. I mean, the ultimate goal here is to bring this property up to grade, develop it into an industrial user, so it can be a viable contributor to the tax base. Any potential user who's going to occupy a 200,000-300,000 square foot building is going to do plenty of due diligence to make sure that the site is acceptable for them, to meet their requirements and to comply with whatever investors or shareholders or Wall Street that they have to report back to for every facility that they operate. So I think
Kevin?
Sure.
Kevin?
Yes.
Can I just add something here?
Sure, please do.
Okay, this is Jane Warren, Commission. I'm sorry, I'm away on vacation, so otherwise I would be there in person. I just wanted to, I'm an environmental counsel with McCarter and English up in Hartford. I just want to remind the Commission also that to the extent that you're concerned about anything being represented by the applicant or by the intervener and not knowing whom to trust, the DEEP is the ultimate in independent authorities here, and were requested multiple times by the intervener, who filed multiple complaints to get out to the site, and they've conducted inspections multiple times as recently as August 17th. They submitted a letter, which is in the record. Mark Jepson submitted a letter dated December 15th. I know it was discussed at the last hearing, but I just want to remind you that Mark Jepson's letter said that they toured the site and there was no visible evidence of any solid waste on the site. And they've also reviewed all the analytical results that were submitted. And they said that the soils meet the definition of clean fill. Soils met the definition of clean fill. So those are two quotes from Mark Jepson's letter. And he did have two exceptions. We discussed those ad nauseum. Those materials did not come to the site that he had questions about. So I just wanted to remind the Commission that the DEP has been there. They've not found solid waste. Again, it's clean fill. And the Commission should feel ultra protected here that the DEP is overseeing, monitoring this with a microscope and a half.
Thank you for additional information and explanation.
You're welcome.
Just one more question regarding future material that comes in on site.
Yes.
Since the intervener and everybody else questioned the previous material coming in, how would you satisfy both us and whoever has a question that clean?
Yeah, so I think, sure. So including our application materials is a material intake protocol, which defines and establishes exactly how material will be brought to this. It provides a list of what's acceptable material, and that's only clean fill. And it actually even excludes asphalt, even though the DEP considers fragments over 4 inches clean fill, we're actually excluding them from the material intake protocol. So there's specific materials that are only allowed to be only allowed to be brought to the site. Everything else is automatically rejected. Staff is trained that any material that's brought to the site needs to be tested before it comes. It's also then stockpiled for a QA/QC, additional testing on site. There's visual inspection. It's inspected with the PID meter, which is for volatile organic compounds. It's brought in, it's stockpiled, there's QA/QC testing in addition to the testing that's done before it even comes to the site. And then that material gets handled and processed and placed in the hole. So I think we've more than adequately defined exactly how we can do that. And I think the commission should have some, hopefully take some comfort in the fact that this application and what we propose from intake protocol is far above and beyond anything else the commission has required as part of any other application.
Thank you. I have no further questions.
Why are you choosing to exclude asphalt?
Well, because there's concern about the size of an asphalt fragment and, whether or not it's inert and things like that. So let's just leave it off the list to avoid any question about it, whether or not it's suitable to be on site. Now, we've also testified, and the commission knows there is asphalt on site, that those stockpiles will stay as stockpiles, and those can be used as aggregate subbase below any future paved areas.
Thank you.
Ryan Arnold Carpet, one other question or statement was, during the hearings, we also agreed to only use natural material to fill up above to the water line.
Yep.
So.
Yep. I do remember that, yes.
It's just easier to make sure nothing that's going to come back and haunt me.
Not only above the groundwater elevation, but also above the impervious liner that's being placed in the top 6 feet of fill.
Thank you. All you?
All right. How much is Stratford High School's in it? How many yards?
I don't remember off the top of my head. It's in the record because it was as part of previous testimony.
What's the volume? I mean, do you have any idea?
I don't remember. I know we've testified to it before. I think it was actually one of the snippets. I don't want to.
Is it 100,000 yards, 200,000 yards?
No. Maybe like 60,000 yards.
Okay. So you say that you're going to bring, well, me and you have a difference on clean fill. We have a difference on clean fill, what clean fill is.
So,
well, on concrete with rebar in it, you consider that as clean fill?
Concrete is clean fill.
With rebar in it.
Rebar would be a deleterious material that needs to be removed from that concrete before it can be placed. But that doesn't necessarily mean it's not clean fill.
Well, what is it considered when the rebar is protruding out of the concrete? Is that considered clean fill?
We are proposing the concrete.
Concrete with rebar in it, right?
Concrete is clean fill. Rebar is rebar.
No, I understand that. But when rebar is mixed in with the concrete, you have to remove it.
Yes.
Is that considered clean fill?
The concrete is clean fill.
No.
The rebar
What about the rebar in the concrete? Is it clean? If it's together as a unit, is that considered clean fill?
I don't believe the concrete.
Are you going to accept concrete with rebar?
There very well may be some rebar in concrete that's received, but the handling of that material would remove all that rebar. It would go in a dumpster, and that dumpster would be removed from the site.
Right, so then it turns into be a recycling facility.
No, it is not a recycling facility. It is not a recycling facility. Under the definition provided by DEP, what we're proposing to do is to import clean fill, remove any deleterious material that doesn't meet the definition of clean fill, and place that clean fill on the property.
And so under waste management in DEP, which I think our town's attorney should call waste management, I believe that concrete that have rebar protruding out of it is considered bulky waste.
Well,
are you going to bury any concrete with rebar?
No, they're going to process it
right, to get rid of the rebar.
To get rebar, so that turns into a recycling facility, which we don't allow that in our town.
This is not a recycling facility. And we are not advertising as a recycling facility.
I just want to be clear on this.
We're trying to be clear.
No, I'm just saying, because if for some reason, this commission approves it, I want to make sure that we don't turn this into a recycling facility.
We have no intent.
For what I understand, concrete with rebar protruding out of it is considered bulky waste. And you have to have a recycling permit for that. That's the way I read it. But I don't know how you read it, and I think the town's attorney should get a ruling from Waste Management before we allow that to happen.
Leon, Commissioner Brodie, let me take a step back. We need 550,000 cubic yards of material, okay? The biggest issue that we're going to face during this process is finding clean material, okay? The protocol that we have written, that we've agreed to, is so stringent that basically most of what we have seen from schools, from other towns, don't meet that protocol. The cleanest and best material that we can get, what I'm going to show you right here. This is clean fill. This is concrete. If it comes to us and has some rebar, we're going to get the rebar out. But this is the best material that we can use to compact and provide the right lifts. So again, we didn't take dirt that will meet industrial standards. We're taking fill that meets homeowner standards, okay? And I can tell you that I've looked all over the state. It's very hard to find that. This is exactly what we would like to use because it is the safest and the best product to use, okay? So if some of it comes in and it needs to be moved on site or the rebar taken out, it will be taken out long before it gets put into lifts because again, the next procedure is I have a whole nother team of independent people who are gonna come and measure and make sure that my lifts are structural. Otherwise, I'm doing all of this for nothing.
I think what I'd like to offer for the commission's consideration is we're happy to accept the condition. We will not accept any hunks of concrete with rebar sticking out of it. We will not knowingly accept any of that. If through the processing, we find rebar inside of the concrete, that will be handled accordingly. But we aren't looking to accept or market or anything like that for big chunks of concrete with big chunks of rebar sticking out of it. That's not what we're looking at.
Well, no, but we do already have that on the site. Because I saw pictures.
Yes, and we've acknowledged that, which was imported from a previous property.
No, well, that's what I'm saying. So I want to be clear on what we're going to take into the
Yes.
site.
But also, nothing is leaving the site. The only thing that is left, just so the committee, so I don't get caught up in semantics, is over the last 2 days, I believe, 12 truckloads of stone dust that I donated to a hockey rink for another town is the only material that's left. The goal is not to take material, do anything to it, and then ship it off. The goal is to get material to this site, fill in the hole, and turn this into an industrial site, okay? We have lots of time and lots of money invested to make sure that we do this once right. I am more than happy to come back to the commission if it's every 6 months or frequently to tell you how we're doing, show you in pictures if people would like to take a walk through with me, as long as it's not during, working hours, I'm happy to do that. There's nothing that is anything but 100% above board that we are trying to do here.
Leon, do you have another question?
Yeah. Is the scale house still on that property?
Yes.
All right. Are you guys going to get permits for that?
It's shown on our drawings as proposed.
So you're,
Our plans in front of this commission reflect that, show that.
so you're going to get a permit?
It's
gonna give them
It's a
Going to give you a permit for the scale house?
It's a trailer. It is mobile. Doesn't require a building permit.
Oh, it's a portable scale.
Yes.
Okay. And I got just a couple other questions here, though. So you wouldn't think that getting Deep's approval on the fill or discussing the fill would be a good idea?
The Deep's very aware of exactly what we're
No,
doing.
but I'm saying there is a thing where you can go out and the Deep comes in and they look at the protocol, what you're gonna bring in and stuff like that. You don't think you need to do that?
We've provided
They've
that.
looked at all that.
Looked at it.
Pre-application meeting is only for when you go to have a pre-application meeting, it's to review with them the permits that are needed for the site. The intervener has, their own consultant has said that the only other permit that they thought might be necessary would be a water diversion permit. And we've spoken with Doug Hoskins as we went through at the last hearing, who has determined after reviewing the materials provided that a water diversion permit is not required for this activity. There are no permits required, so there's no need for, it's like asking us to go to Nuclear Regulatory Commission for a finding that we don't need a permit. We don't need a permit. There's no need to have a pre-application meeting. Have we talked to them at multiple times? They're fully aware of this site. As you know, they've been out there. If they thought there was a permit that was needed, they would be saying you need to get a permit. You don't need a permit for clean fill.
And if they determine that there's something we'll need, we'll go pursue it. And we'll even agree to come back to this commission and tell you exactly what they say.
All right, I had a question. Oh, okay. At the last meeting, right, because we're going back to in December there, Mr. Green just said that you stated that you had every document in December that were ever brought into that property. But at the last meeting, you said that you had to get it from New England Material. Which one is true here?
Would you like me to answer that?
Sure. Mr. Carter.
We have what we have, okay? The prior owner is under no obligation to give me anything more than he has. So after the last December meeting, you guys asked if we had sent that to Deep. The next morning, I called the prior owner. I said the P&Z would like that to be sent to Deep. We got a letter that says he has sent up everything that he had, I believe, to Deep. Okay, Deep has it. I guess they're going to review it. But again, I can't create documents that we don't have, but it is pretty clear that this has been a very clear and transparent process of what we've gotten, what we're able to give to the commission.
And
Mr. Ambrosi may be asking why you had said before that you provided all the documents, because you did provide all the documents that you had. You didn't buy the business of New England Materials, you bought the property, so you didn't have their records, and that's why you said you'd provided everything that you had. You didn't have all the other documents.
And we had previously provided to this commission as part of the record of the previous application, which is part of the record of this application, manifests and emails and testing information that we had at the time from New England Materials.
That you had manifest.
Right.
Right. And then at the last meeting, you said that you had to get those from the previous owner. I'm just saying what was said. And so I have concerns about that because for the reason why you didn't send it, what was at the last meeting, was that you didn't have it. And that's why it never went to Deep. And now all of a sudden, you had it, but then it went to Deep. But I'm just saying, you got to understand where I'm coming from, because I sit here and I take this very serious, this part of this, okay? Sure. Because this turned into be a disaster. And I'm not saying it's Mr. Karp's fault or not Mr. Karp's fault. It's not really Mr. Karp's fault. But on top of it all, we have to make sure that we get this right.
Of course.
Right. So when something's said in the meeting, and then all of a sudden somebody says something different that happened, then it doesn't, you know, it's like everything changes as thing goes on. And it's like, it's concerning to me. And that's the reason why I have all these questions. And I asked you about with rebar protruding out of concrete, I believe that's considered bulky waste. And if that's what you're going to bring in, that turns into a recycling facility. And I just want to be clear on that.
We are not proposing to import any bulky waste to the site. We're proposing to import clean.
All right. So that's why I think, on top of it all, that you say that we have an LP from wetlands, but wetlands has nothing to do about the fill. They have nothing at all to do about the fill. Okay, we're the ones are controlling the fill. And we're the ones that need to make sure that we get this right for the town because we have to make sure for the health, safety, and welfare of the town.
Of course.
And so I say, you know, I keep on saying that we need an independent. I don't know what the rest of the way the commission feels about it, but like I say to you all the time, is that we get different answers all the time here. It's just not like I'm getting a straight answer, you know what I mean?
Mr. Ambrosi, I take offense to that.
I'm not saying it came from you.
Okay, but this line of questioning is trying to create.
I'm not creating a
This
distrust.
applicant has done nothing but be forthcoming and open with this commission, and I understand the concerns.
Do you have another question?
No,
We're not here to
I'm not
argue.
going to get, I'm not arguing. I don't want to argue, and I'm not arguing.
Let's stick to the
I'm just putting out facts. That's all I'm putting out is straight facts of what was said to me in this commission. And that's what I'm putting out. And you wonder why that I have a problem with what is said to me. It's been said to me like 2 or 3 times in this happened. And then Mr. Finn's going to jump up and he's going to try to ream me again on something else. I really don't need that.
We're not arguing here.
But I just want to bring it back.
No, I'm just saying, I just want to put it on the record.
No arguing, please.
No arguing.
We're just finding
Security
the
left for
facts.
the night.
No more questions.
Thank you.
I actually have some questions. Shocker. Do you have with you today the map of the boring holes?
I do, I think.
Can you pull that up for me, please?
Sure. See if it's on here. Perfect.
Yeah. Ready?
Yep. So just for the record, this is a figure from WSP's site investigation report, which shows stockpile sampling locations, monitoring watering sample locations, and subsurface water sampling locations.
When this property, before Mr. Karp took it over, the mining process started where? The original.
Sure. Permits were originally approved, I think, in 2006. The excavation activities started on the southern end, and that excavation continued from south to north.
Okay. So here's where I have an issue. When you go from south to north, you have a lot less boring holes than where you do in the north. And then where that was in the south, down south over there, it was pretty deep, those holes, and they were filled, correct?
No, as this excavation took place, this is all ledge at around elevation 430. So the previous activity, there was a crushing plant set up here. So they came in, they removed material to elevation approximately 430. They had a plant set up here, which included jaw crushers, cone crushers, screeners. So there were stockpiles all around here. From this point was all excavated to elevation 430. From this point north, they started to go deeper. And it goes from approximately 430 here to approximately 410 or 411 here. And then there was one spot which went deeper than that. But the floor did not go past 415, 410, 411 as you went from this point on the site north. And I can attest to that because my office conducted inspections and provided quarterly reports to the town of Monroe from 2014.
I wasn't here at that time.
From May of 2014 through the third quarter of 2018. And that entire time, it was an export activity.
So there was no hole ever dug there that was filled? Nothing was filled?
There are areas through here.
No, I'm not talking about there.
No.
I'm talking about the original spots.
Nope, nothing. This is all, at this point, there's dust and stuff, so there's probably a couple feet of screenings and tailings and stuff is just over the years of the activity, but this was never excavated, to my knowledge, from what I observed, and I my experience on the site going back to 2012, none of this area was ever, to my knowledge, excavated below that.
So what was there? So what was there, a big mountain on there?
Yes.
It got taken down?
It was a mountain.
I don't remember that
Yes.
because I was not here for that.
This was a mountain. And that ridge line ran right through here, which is why this area used to contribute to this easterly wetland system. When they did this excavation, it reduced that watershed.
Because when I walked it, there was definitely rebar sticking out of the ground. So
there's a stockpile here.
no, the rebar was by the scale.
Down here,
That's not there.
Yeah. Uh-huh.
over here.
Where you have
There's
these,
a detention basin over here.
where there's stone dust.
Sedimentation basin.
You know where the big piles of stone dust are?
That's,
Yeah, there's a little pile over there of concrete
and it's still
too.
there, and it's still there.
It has to be.
It's a pretty good pile of
Oh, there is.
concrete.
So no boring holes can be dug in those areas because you're at ledge already, currently.
Yes,
You have refused.
You're done.
a foot or
yes.
two.
Okay, I just wanted to clear that up.
And I can add further, that's where the detention basin for the site goes, and it's in rock.
Okay. So I also went back and I listened to the,
Where's up top?
when I'm going to pronounce it wrong, but Arcadis
Yes. Okay, yes.
did their presentation in front of wetlands. And I guess one wetland, there's no chance of it coming back?
We disagree with that. We disagree. Our soil scientist and our expert disagrees. And I'll say that, so this easterly wetland system.
He used it cooked like
Toast. He said toast. He referred to it as toast. We disagree.
something about Thanksgiving was in there?
Yeah. Our wetland scientist disagrees with that. And we've actually, as part of our approvals with wetlands, we've actually started to pump groundwater to this wetland system to try to rehydrate. And actually, our soil scientist testified during the last hearing that that's actually showing signs of an evidence of improving the hydrology within this system than what was there previously.
Okay, so
Just so you, maybe you heard this, but the percentages were this. The interviewer testified at the very first hearing, the first application, that there was a 50% chance that the wetland could be brought back.
Yeah, agreed.
The Arcadis said 30%, and our experts said close to 100%. But the overall goal is to try to restore wetlands, not recreate wetlands. And it was on that basis that we went back to the Inland Wetlands Commission with our second application. Said, what do you want? Do you want us to try to restore the wetland? Because that is the gold standard. And they said, yes, that's what we want you to try to do. And that's why they approved our second application, which is why we're before you to get an excavation and fill permit to really implement that plan. Thank you.
In the water? No.
I'm good. I have no more questions.
That's the other side.
Go ahead.
So I think myself or any of the commissioners up here at this point, we're going to have trouble asking any question that hasn't gone over,
We're not sidebar.
I just want to be reminded,
Comparing the picture, that's all.
exactly what fill is going to be used to the water, cap water line.
So there's native material that's on site that was from, there's quarry screenings, and then there's overburden. So the native material that was on the site, as the rock was crushed, it creates a finer gradation material. That's all been stockpiled here. The commission probably remembers, it's a huge pile. There's also along this eastern side of the site here against this face, that's overburden. So that's the material as the site was being excavated, any earth material that was above the bedrock, that's called overburden. So that's the topsoil was separated, but that's, the glacial till, the dirt that was above the rock. All that material was stockpiled here. So only that native material between overburden and quarry screenings will be used to place below the groundwater elevation and then above the line.
What's the likelihood of any potential contaminants getting through the membrane? In your experience?
You never want to speak in certainties, but 1%, 2%, I don't believe there's any likelihood. of any reasonable likelihood of any contaminants, because we're not proposing to import anything with contamination.
And what's the likelihood of a contaminant getting in the water supply now?
My opinion, none.
High.
Oh, in the current condition?
Correct.
High, much higher than through our proposed activities.
It's wide open.
Yeah.
That's part of the reason that's part of the reason we want to go fill this. Doing nothing is, we've been here for 2.5 years, hasn't helped the situation. It has only made it worse.
That's all I have.
I agree with Rob. Most of the questions I've had have been answered in several different ways and times, but just want to
Ask them
review.
differently then.
Not my style. About how much material are you looking to bring in? I know I've heard a few different numbers. I just want to kind of get a
It's actually,
set here.
it's actually 490,397 cubic yards.
Okay. And that's going to 464? That's going to about 464 feet?
So our elevations. Here. The front portion of the site is going to be filled to approximately elevation. Oh, go ahead. 436, and then the upper portion of the site towards Independence Drive is going to go up to 460, 462.
The reason for the two difference is in
Trying
order
to-
to
yeah.
get water to the wetlands. That's why the back is going up so high.
Okay, makes sense. And thank you for allowing me to tour the property today. And Rick, can you just point out for me on the map, now that I've seen it, it gives me a good perspective, where exactly is the Stratford High School debris?
Right there in the black.
Okay. And that's all pretty filled in right now because we were driving right over it and it's pretty impacted. It's all going to come out?
It all has to get processed in place.
Okay.
And engineered lifts and hit with a roller. And again, there's all this concern about what was brought to the site. And if it's 30 and maybe we missed something, it's all got to get handled.
Well, like you said, between the time that you were involved before and now, there may have been, who knows what happened, but.
It's all going to get handled again. It all has to get processed in place.
And when it's being put back in place, remember, it has to be put back in such a way that it's structural. So there's people watching it as it gets rolled. So again.
And test it.
And test it.
Test it with a nuclear densometer to ensure that it's hitting certain compaction results.
Okay, no further questions. Thank you.
Dominic?
Sorry, I have one more question to Mr. Carr. The owner of, is the applicant, you are the trustee, am I right?
I'm the managing member.
Managing
yes.
member, okay. And the Astro Land Holding LLC and Spacely Land Holdings are the actual owners?
Yes, of which I'm a percentage of them. So it's the organization that's doing it, and then it has two partners underneath, of which I'm one of the partners.
Thank you. So the previous owner, New England Material, sold all its holding ownership to the two LLCs.
Yes, we bought the land,
You bought the land.
correct.
What else did you buy?
That's it. And some equipment, but we did not buy the business.
Okay. Is there still some, is the owner, previous owner, have any holding with the new corporation?
Absolutely zero.
Zero.
He has been helping us through the process because he knows the land and the history far better than I did. So he is a consultant, but he has no financial interest above just being a consultant.
Thank you.
Okay, do the commissioners have any other questions? Before we go to the public. Okay, as this is a public hearing, are there any members of the public, either in person or online, that would like to comment on this application? Any members of the commission?
Correct.
Any members of the public online that would?
Got a raised hand.
Ron
this.
Banowski has raised his hand.
Where is he?
Go ahead, Ron.
Go ahead, Ron.
It's in the top left
I
corner.
have to unmute him.
You gotta unmute yourself, Ron.
Yeah, that's self-created.
Is it unmuted?
Yes.
Yeah, you got it.
Yeah.
I've been following this very carefully. I've also been a resident of this town for over 47 years. And this originally was to be a natural habitat because of its rough nature and the fact that it was a prime water source supply, which the Pequannock River, it feeds the Pequannock River, which feeds the Pequannock Reservoir, which is a backup water supply to the Easton Reservoir. So it's a GAA water source. That's a critical resource. It should never have been broken up, but that mistake was made years ago by ignorance of the classification of the land. And it still, however, is a GAA water source. What has been Aquarian position on this? They're the stewards of the water. They are a organization that has to be informed. And what I don't remember during any of the meetings that I attended ever saw a report on what their position on this was.
Do you have any other questions, Ron, or?
I would like an answer to that. Is that possible to get tonight?
Yes. If they're willing to answer that question.
Yes.
Well, I have another.
All right, go ahead, Ron. Then we'll have them answer all the questions.
Okay. Well, this one here is more or less my opinion of this property. And the town. I do not believe the town of Monroe has the capacity to monitor anything, any piece of property of this significance. The charter of the Planning and Zoning Commission is to provide a development of a town and obey all of the state statutes regarding development and planning and zoning commissions, which primarily are regarding health, safety, and general welfare. Safety. A prime water supply, a GAA water supply, is of the utmost and one of the most important and sacred things a planning and zoning commission has to deal with. And it can't be dealt with out of ignorance. And I'm not blaming anybody here right now. This was the mistake. The primary mistakes were made years ago by tearing down or developing a section of town that was determined back in the 50s by, I believe, a group from Yale University, where what was the best way to develop a town and protect the critical resources and develop it where it was feasible. So not everything in the town should be, especially critical resources which involve health and safety concerns. And the town of Monroe has demonstrated 13 years of this thing being degraded, scarred, whatever you want to call it, happened because ignorance prevailed and nobody assumed or even knew what their responsibilities were to monitor, audit, and see to it that any violations of permits were dealt with in a legal way. Now, the people who this New England materials or whatever, it's getting away scot-free. We don't even know what they did. How can we, if we haven't determined the root cause of how they were able to get away with what they got away with in an area that's a critical resource, how can you even consider passing on or voting on something without a plan that identifies those errors, the root causes, and provides a plan that provides corrective action to make sure that it can never happen again? you shouldn't even go any further with this in terms of developing it. Remediating it is something else. That's where the concentration should be. But there should be no intentions, no efforts to develop it if it remains a critical resource. That's why I'm asking the question of Aquarian, and that they have the authority and the responsibility to protect water for all of Fairfield County. In fact, the water sources for Fairfield County were used to provide backup water during the water shortage a couple of years ago to New York. That's how critical this area is for developing water. There's two major reservoirs, local area reservoirs that use water that emanates to some extent in Monroe. The Easton Reservoir and the Trap Falls Reservoir in Shelton can be tracked through and originating from rivers and streams in Monroe. And I'd like some comment on that from whoever has answers to them, and why are we even considering and talking about developing this land right now when we haven't figured out what went wrong for 13 years that nobody seems to have been able to do anything about, and nobody's been held responsible. In fact, these people seem to be moving out of town rather rapidly.
Okay, thank you, Mr. Banofsky.
Thank you. I'm going to unmute now. Or mute.
So thank you again for the record, Kevin Soley. Just to comment on the concerns about Aquarian. So Aquarian is actually a direct abutter to this property. And thankfully, the intervener actually made several complaints to Aquarian. They were notified through the application process via certified mailings, but they're also notified as a direct abutter. And they also received several complaints from the intervener because he has demonstrated his concern about the environmental integrity of the property. A gentleman by the name of Joe Welsh, who is a senior manager for Aquarian, came out to the site, toured the site, inspected everything that was there, found no issues, created no actionable items. We had several correspondence with him, and he determined that there was no concern or impact to the water system whatsoever by any of the prior activities on the site. And we shared all of our proposed activities, and he saw no concerns with what we were proposing. So,
thank you.
If I could just add one point, and that is obviously, sometimes we lose part of the pun, the forest for the trees. This application is to restore this property and make it more environmentally beneficial. That's what we're all about here. Subsequent applications may include site development. That will have to come before you, will have to come before the Inland Wetlands Commission. But this application is beneficial to the environment, beneficial to the wetlands and the water courses. Thank you.
Okay. Are there any other members of the public here or online that have any comments or questions for the commission? One more time. Are there any members of the public that have any comments or questions for the commission? Okay, hearing none, then I'm going to go to the intervener for, I believe you asked if you could address the commission briefly, one further time.
Well, this is why I was hoping to ask the question sequentially, because there are a lot of things that didn't quite get covered by the applicant.
So I'd like you to ask us
happily
what you're concerned with, and then we can go from there.
Are the applicants charging to receive bill at the site? And that is relevant to your jurisdiction. That question was not answered. Next, after all this work and all these characterizations and round and round and round, and all the analysis that the applicant will tell you that they've carefully done, they have not answered for you how many yards of fill that they are going to process. They are very subtly using the term handle, but they should be able to tell you how much rebar, and I note the comments by various commissioners about the material on the site. They should at least give you an estimate of the material that's going to be crushed. that's going to be.
Can I ask you a question about that?
Yeah.
How would they know? What if they go to every landfill in the state of Connecticut and everything is clean and everything's just dirt? How would they know?
Well, they already know that there's material above ground, they said.
I understand, but how, I think that's.
They know what's there, but they don't know what's there.
How do you know what they're gonna bring in? Nobody knows.
But
You don't know, I don't know, Mike doesn't know, nobody knows.
I don't follow your question. There's.
You want them to give you an estimate of what they could potentially bring in that needs to be.
No, the existing material on the site.
Existing, he's asking.
You're not asking about what they're bringing in?
No, what?
Well,
No, you asked for an estimate of what they're bringing in.
I had asked that question earlier.
Right, but how would they know?
Well, let's put that aside. Let's put that aside. My question is on site. They've investigated on site.
That wasn't.
And I said, Commissioner, you even remarked that you saw rebar on the site sticking out of the ground.
I did, and they answered the question by saying that there's a stockpile over there that they haven't touched yet.
Okay, but they should, if they are asking, again, improvidently for this waiver, they should be able to tell you the magnitude of the material that they are asking for a waiver to process. Some magnitude.
Just to process what's on site?
On site.
Only.
There's this problem.
No.
Yes.
Only on site.
Presently. All this investigation.
That makes more sense.
And they've said, quote, how many times have they said exasperatedly in response to me, we've tested all the material, we've tested everything. Well, then they should be able to tell you, after all that testing, approximately roughly, how much material they have to, quote, process or handle or however you want, or recycle or whatever term you want to use. How much crushing are they going to do to remove rebar that is presently on the site? And we know a lot of it came in these 60,000 cubic yards of Stratford High School that is in the ground and piled up on that site.
Sure, I'm sure they have that answer.
Well, I hope they do, but they haven't provided it. But please press for that.
Kev, do you have that answer?
Sure.
I'll press them right now.
Hi, for the record, Kevin Zola.
How much rebar do you need to handle, process, recycle on that property currently today?
I can't tell you a number.
Okay.
Let me explain why. This
Please
material,
explain.
the truckloads that were brought in, the materials were brought in, truckload was dumped, the truck left. Another truck came in, dumped material and left. The stockpile that's out there is a big stockpile. And every time a new truck came in, it drove over the old stuff.
Okay, give me a rough idea.
I can't estimate how much needs to go be processed because it's been sitting there and it's been driven over again and again. And a lot of that concrete will break down. So I don't know how much concrete is over 5 inches in size.
How many truckloads roughly came in then?
I believe, well, Mr. Green testified before that there were 1,500. I don't know. I wasn't, that took place during a period when the applicant didn't know it, and I wasn't involved in what was going on. It happened in March.
So Miss Warren should have been involved, correct?
I don't believe Ms. Warren was, again, she's an environmental attorney representing clients. She wasn't involved in what was going on at this site at that time. So I don't know how much material in that stockpile is over 5 inches in size that needs to run through a crusher. I can't answer that question.
Let's assume it all is. How much, if the whole entire pile has to be crushed, what are we talking?
Before Mr.
Let's just do it
Ambrosi
that
asked
way.
the question, and I think I said maybe 50,000 yards. One of my engineers that's with me actually thinks it's far less than that. It's more like 30,000 yards or 25.
That's the only safe way to really estimate right now is just to.
So your answer is
assume the whole thing and then
Whatever
overshoot
it
it.
needs to get the rebar taken out of, we're going to take it out of. Why this question is paramount or has anything to do with the application, I have no idea. But whatever, again, we have said that the material is going to be dealt with because it's got to be touched, to be put into lifts, rolled. And so again,
Well, our concern, Mr. Harp, is that material is brought in there illegally. because they didn't have a fill permit. That's our concern. And we don't know really what it is.
And
And we don't know what's down in the ground. They said there's red brick. Is the red brick painted or is not painted? We don't know any of that because it's in the ground right now. So we have no idea of knowing any of that.
Mr. Ambrosi, it's stockpiled. It's
I
not-
understand, but we can't see the whole stockpile. It's not like, it's not like up in the air.
entirety of that stockpile is going to be dug up and placed in engineered lifts.
Right. So if there's
The problem right now, though, illegally or not, it's there.
And we're proposing to deal with it.
Thank you.
Right, if
The problem is, it's there, correct?
Yes.
And you're proposing to go through it 100% and get the clean stuff in a hole properly and remove the stuff that's not.
Correct.
Thank you.
Let me let Mr. Green finish. Mr. Green, go ahead.
You do it this way.
Mr. Solly has said to this commission 3 times, and you can read the snippets, that there is material from Stratford High School in the ground. The core, those WSP reports show that there's material in the ground, in the water table. There's asphalt in the water table. So I have a few more questions, but let me just throw this out there, and I haven't discussed it with my client. In the disappointing circumstance that this commission grants this application, maybe something that should be thought about is condition. Number 1, process this material, dig it up, figure it out, and process it before another load of material comes onto this site. Let's get to zero. Let's back up and get this thing back to pre all this junk going into the ground and being stockpiled on this site. Condition 1, process, dig it up, excavate it, deal with the stockpile, which Mr. Solly said 3 times, and I urge you to look at the snippets. He said it's in the ground. And the reports say it's in the groundwater in certain places. So let's back it up and back up to where the site was over excavated. And before everybody started playing hide the debris and filling and grading and messing around on the site, let's back to zero. If this is the path you're gonna follow. Doesn't that make sense? And isn't that something responsible to do for the citizens of this town? Back it up to zero before you bring in any new material. So I'm just throwing that out there. Are they charging to receive fill? Yes or no? I asked that question. It hasn't been answered. A sort of tangential.
I actually think Mr. Karp did answer that question in a previous meeting. I think he is charging to take in fill. I think that was a question that was asked before.
Fine, I just wanted clear on the.
Mr. Karp, I'll ask him. Come on up, buddy. Come up here, let's have a little conversation. Are you charging to take in fill?
in certain cases, yes.
What are those certain cases?
Depends on where we can get it, if we have, what we need to do to it, what our costs to test it are. Yes, there will be certain fill that we will be charging to roll it.
Okay, thank you.
What, follow-up question, will you also be buying fill to fill the hole?
Yes.
Okay, thank you.
Somewhere I have to come up with 640,000 cubic yards. 490, sorry, 490.
Thank you.
Go ahead, Mr.
193, 600.
42.
In terms of my comment about the 1,500 yards of fill from Stratford High School was only 1,500 loads, rather, I'm sorry, that's just roughly, and I had asked the applicant, you know, they had submitted this letter to you, Attorney Warren's letter, December 22nd to DEEP, and they did not provide this commission with the exhibits and enclosures, which I did today. And I asked them to go through it because it has a lot of Mr. Kimball, New England materials are included. And I just, using the ticket numbers, guesstimated somewhere around 1,530 or 1,540 truckloads. That's not all the New England material. The sequence of the tickets led me to believe that that's not all of the New England materials stuff, but that, I just throw that number out because it's more than that. That's a gigantic amount of material from Stratford High School. So that's something the applicant should be able to answer or should be able to obtain, but they should review the documents that the enclosures, and they did provide the letter, but not the enclosures again. I certainly take issue with characterizations of the law on Phil, but we're not going to go through that again. That's not for this commission to interpret. I understand that, and we'll do that another day in another forum. Let's see. Look, I also take issue with, we're letting the applicant show the WSP plan from before a meeting a year ago, and the applicant had explained it, but I urge you to look at the snippets. They're in the record, and I take issue with Mr. Soley saying it's disingenuous for me to ask you to watch a 3-minute snippet of his comments to the commission. And when you do view those snippets, you can judge who is being disingenuous. And with that, I will sit down. We urge the commission to deny this application. If you look at the videos over the year and look at the information, it is not a puzzle. There's a lot of missing pieces. There's a lot of missing information of what exists on that site. But if you are going to go down this road, and we've laid out all of our arguments, think about that condition. Get this site back to zero first before anything new comes in. You can impose those kind of conditions, and the applicant may not like it, but it's the responsible thing to do if you're going to do it. But we urge you to deny the application. I don't know if you have any questions for me, but I've given you these questions. One question I did have. Are the lot lines shown on the proposed plan as they exist now, or is there some sort of lot line revision in the offing? That's a question that you should ask the applicant as well. And are they seeking some sort of approval of a lot line revision through this application, which we also submit they cannot do in this context?
Okay, thank you, Mr. Green.
Thank you.
All right, we're going to go to the commissioners. Mr. Green has addressed us with some concerns. And if you would like any of his concerns to be answered by the applicant.
Sounds like they want to answer.
Well, I'm going to go through the commissioners.
Oh.
I'm getting, Mr. Green, to deny this application. What would you want to be done with this site?
A lake.
Ultimately?
Yeah.
My client did say he'd love to see it turned into a lake or turned into a park, but putting all that aside, under any circumstances, there needs to be an appropriate remedial plan after an appropriate investigation of this site, and one that complies with all of the regulations, your zoning regulations and state statute on waste and fill.
But as I heard the applicant say that he's going to handle all the material. And from what I know a little bit about handling material, if he was telling me that he was going to handle a third or half or a portion, then I would be concerned. But he was going to handle it all and process it right to be able to be used on the site. So what objection would you have for that?
First of all, it's interesting you use the phrase handle because the applicant uses the phrase handle. I agree with Commissioner Ambrosi. They are basically recycling and processing material on the site, which is not permitted in this instance. I don't believe that any of the activities comply with your zoning regulations. I mean, I've made these arguments, and I think that this commission should require a much more vigorous review of this plan before you set. And by the way, let me go even further. This developer and the applicant stands before you. This applicant has gotten a cease and desist order, notice of violation. This applicant is trucking material off the site even within the last few months. After the cease and desist, materials have been removed from this site by truck. My client is with.
Please just address this question. What'd you like to see done? I think you have.
I would like to see this denied, and I would like to see a more robust investigation. I would like to see whatever was done to that site. This owner bought it knowing what was there and knowing the condition of this site. And this site should be backed up to zero. It should be clean. It should be fully investigated. Brick, asphalt, and materials that are in groundwater, admittedly, based on their reports, should be removed. And we would love to see this remain as a park or as a lake, but under any circumstances, it should be cleaned before it proceeds. And this applicant shouldn't be able to turn this thing into some kind of financial bonanza by receiving materials for profit and not paying the full price of being responsible and overseeing the remediation of the site in a manner that addresses everyone's concerns.
Yeah.
No questions.
Commissioner Peachy, do you have any other questions?
No, I have no other questions.
No questions? And Commissioner Ambrosi?
Just one question about the red brick. They talked about the red brick. Yeah, you, Kevin. You know what that red brick is, or you don't know? You have no idea.
I can't.
So you don't know if it's painted or not or any of that. Is that all going to be torn up out of there?
It's all going to, yes.
Where did that red brick come? Is that part of Stratford High School?
I
don't know.
I don't know. I don't know off the top of my head.
Okay, that's all I.
But it's all going to get.
No, I understand. I just.
Processed.
No, because.
Whatever you want.
Commissioner Mayne? Any questions?
Nah.
Commissioner Westland?
No questions.
Commissioner Lupo?
No question, but just a comment regarding the lot line revision that was brought up. I thought that was something that Inland Wetlands asked you guys
Yep.
to do.
I was going to provide a response to that.
Okay.
Inland Wetlands requested it. It was part of one of the things discussed at their hearing. And that lot line revision has been filed on the land records. That lot line revision is in effect, and our application to this commission reflects the lines as currently exist in accordance with the records in the clerk's office.
Question. When you're done.
I'm done. All you.
Mr. Carp. Oh, Sully, come on, you can stay up there. You guys make a nice team. Mr. Finn, you can sit down. What are your thoughts to what Mr. Green said about remediating what's there currently before you take in another piece of clean fill?
I've spent 2 years, probably missed out on 100,000 cubic yards of fill waiting, okay? Everything has to be handled, processed. I need to be out there sourcing. I need to get approval from this board. It's not like tomorrow somebody's gonna call and say, oh, by the way, I have 80,000 cubic yards of clean, tested material. So holding us back is the same thing that this process has done for 2.5 years. There is no reason that they cannot be done simultaneously. We could take in material on one side of the site, test it, and on the other stockpile it, and on the other side, we're going through the material that's already.
How long would it take, roughly, because obviously we don't know what's there. How long would it take for what's currently there to be, let's not use handled because that seems to be a very hot topic today.
Relocated in such a way.
Taken care of, whatever's there currently, how long would it take roughly? Would it take a month? Would it take a year? Would it take 6 months?
I think it's 6 months to a year.
Of currently what's there to be processed correctly?
Correct, because again.
Crap taken out.
To get the right compaction, you can't just take.
I'm just talking about what's currently there. Take it and put it in even if you put it in a stockpile of what's good and what's bad, how long would it take for what's currently there today to sort out?
I would probably estimate, just to kind of go through that all, it's probably 6 months. I mean, there's the whole, there's a lot of activity that needs to take place, and And frankly, to Mr. Carp's point, I think that the 2 years of delay, which has been, challenged because they, unreasonable pollution to the environment, which hasn't been counted, we've lost out on.
Right. So how could, so let's say you do them simultaneously. How can we ensure that that gets done?
Here, we have, so they're always, already.
Yeah, but I just want to hear them say it.
Okay.
I've read it. I don't just.
You're going to provide.
Okay, you can read it
funds
for 'em.
For the inspections.
Yes, as part of our.
Yes, you're gonna get right. I don't think this commission is gonna,
that.
I don't think the commission is gonna put an approval in if they approve it without an LEP. I don't think that's happening.
Can you describe what that means?
Like,
Why don't you let us know what you've proposed and agreed to do to inland wetlands as far as inspecting what's going forward?
The Inland Wetlands Commission included a condition that the applicant is responsible for supplying funds to the town to engage its own professional to inspect the activities on the site and to report back on the progress of the work.
As it's going forward.
Correct.
And what specific activities is that?
The Wetlands Commission has to actually go prepare a scope and go solicit proposals, which they're working on as part of their.
So there's not a scope that they gave you? That what they were going to have?
No, they
have an
left it in.
open checkbook.
Yes.
I mean, so when everybody says about the money that we're going to make,
You got a wetlands approval already.
We do. And
I believe it's not in there?
Oh, it's whatever they want here. They can, the wetlands can, whatever they want.
Whoever they hire can write their own scope, and this is like an open checkbook.
From the wetlands approval, the owner will provide funds for regular periodic inspections by a neutral third-party company with the proper certifications to be chosen and hired by the Inland Wetlands Commission. This professional will develop inspection criteria and provide written and verbal reports to the Inland Wetlands Commission. This inspection will include performance of the well and pumping, restoration progress of all included wetland and vernal pools, and any other.
It only has to do with the pumping in the well.
Defined by the third-party company.
This only
shall continue for the duration of.
Right, but that's for the wetlands approval.
That's for the wetlands, that's only for the wells and pumping, right?
No, it's the wells and pumping, restoration progress, of all included wetland and vernal pools, and any other criteria to be defined by the third-party company. Yes,
Yeah,
it's an open checkbook.
but we can't require it of a third-party company because we're a commission. We're a planning and zoning commission. Only the third party could be done through wetlands, right?
I believe this
Because-
commission can.
Yeah,
It's going to be done.
explain the piggyback.
Not all.
What's that?
Yeah,
Only wetlands could do that.
No. Kevin, what's the piggyback approach?
the planning and zoning commission can piggyback on the wetlands condition and have those same reports be provided to the.
Yeah, I mean, we talked about this 100
Yeah.
times.
So they
So we're
can.
gonna be
We're gonna use
part of
the inland.
licensed professional.
Yes,
And it's inland wetlands and planning and zoning is gonna be
as a condition of approval.
a condition approval.
Yes.
You have to do that.
And so we can put what we want in there too?
Absolutely.
Okay.
That's what I was trying to get you to say.
Which, and then,
It took a lot of mouths to get that done.
no, I want to be,
On the other hand, during this whole process, we've been painted various ways. None of this has been done on our watch. We were told to stop blasting, we stopped blasting. We've sort of lived to the letter of the law, and yet, I will have to prove 9 different times that it's not polluted, we're doing it the right way. I have my own consultants who are gonna tell me how, it has to be put in lifts. I mean, at a certain point, please understand that, it still has to make some economic sense. The town has just hired somebody for P&Z and I believe others as a town inspector. I worked with him in another town. Again, at the end of the day, this isn't it is owned by myself, partners, my family. So, everybody was concerned at the last meeting that it would get sold. Anybody who's going to come spend the type of money that it takes to develop or buy this is going to require due diligence that is volumes, okay? There'll be phase one, phase two, they'll do 1,000 more test borings. So there's nothing here that is, not going to come bite us 10 times over if we don't do it the right way.
Do you have any other questions?
Me? No.
Anybody else?
I'm sure I'll think of something later.
All right, if not, then we'll go to close this hearing.
Well, hang on.
Whoa.
I just wanted to offer, there's a couple of housekeeping items.
Oh, I thought you were double talking.
Just
We won't close it.
housekeeping standpoint.
You like to bang the gavel just as much as I do. Just as much as
There are some comments from engineering from Scott Schatzline that.
Hold on.
Excuse me.
We can close it.
Okay.
I just wanted to say that there are some, we received comments from Scott Schatzline. We provided a response. He gave us a response to our submittal. The comments that are outstanding, we can accept as conditions of approval to satisfy exactly what he's looking for. So I just wanted to put them.
We have those comments?
Yes, they're in the file. They're in the record. They're in your packets. So we're happy to accept condition to satisfy all of Scott's comments as conditions of approval. I think we may have a couple of housekeeping.
Yeah, I just need to do one quick thing for the record. And I do just want to address one thing in Attorney Green's last comments. Again, he asked you to take a look at the snippets. I object to that. It's cherry picking. You can't just listen to a portion of a snippet of a hearing without hearing the entire hearing. That's point number one. Point number two is, and again, this is a procedural matter that I need to put on the record. I think you all know that Mr. Metropolis asked Mr. Green to file what's called a verified amended notice of intervention. And Attorney Green in his remarks to you have cited statutes and you got to do this, you got to do that. The fact of the matter is that an intervention petition is governed by the general statutes. And in order to have a viable intervention, your intervention pleading shall contain a specific factual allegations setting forth the nature of the alleged unreasonable pollution, impairment, or destruction of the public trust in air, water, or other natural resources in the state. I submit to you that not only their notice of intervention, which I assume you all have, doesn't meet that criteria in the statute, but that nothing that they presented to you rises beyond speculation or conjecture. We've heard all about, well, you have to be worried about this and you have to be worried about that. But there's been no evidence that provides support or corroboration that anything having to do with this application, which is to restore and remediate wetlands, is going to have an adverse environmental impact or an unreasonable pollution in our air or water or resources. So I want to state for the record that the intervener petition has not satisfied the statutory criteria and should be rejected on that basis, and that it would be impossible, in my view, in connection with this application that's already been approved by the Inland Wetlands and Watercourses Commission, in response to a notice of violation, that we must remediate and restore the wetlands, that they could ever meet that burden in connection with this application. So I just want to state that for the record. Thank you very much.
Thank you.
I certainly second closing the hearing at this point, Mr. O'Reilly.
Would the applicant like to close the hearing?
Mr. Chairman, I would like to ask another question, if I may. I've had my hand up for quite a while. I don't know how it registers over there.
Go ahead, Mr. Benofsky. I guess we didn't see it during public participation. Go ahead.
Okay. I have to believe that something went wrong very early in a process somewhere. Stratford High School and whoever else may have been part of providing the material to New England Materials had provided some kind of paperwork certifying what the material contained. There had to be somebody in New England Materials who accepted that material, for some reason, which I don't think they had a permit to reprocess or to take contaminated materials, but they did anyway. But what's going to be done differently, and what measures have been put in place to make sure that that same kind of poor management of what's being supplied and who monitors it and who sets the standard for the demolition of a high school? That was a rather extensive construction. And I believe Mr. Green, Attorney Green, said he counted something that would indicate took something like 1,500 truckloads of material from Stratford. Is that more or less that should have been for a high school that size? It was a pretty good size high school. I don't know whether 1,500 is a good number, or were they accepting material from some other source and processing it through the guise of a Stratford High School demolition? Did somebody else contaminate the system somehow? How would we prevent that? Is that possible? And believe me, I'm sure it's possible. There's something went wrong there that was not monitored. Who's responsible? I don't think the town of Monroe is capable of investigating all of that, but it seems to me like there was the potential for some kind of criminal activity there. And is there somebody else who's responsible who should be part of the remuneration to Monroe for any costs, or the current person trying to remediate it? This happened for a reason. Somebody did something they shouldn't have, and it's hard to believe it wasn't done intentionally. How are we going to prevent it is basically, and what standard is the material supposed to meet before it even gets put on a truck? And who monitors that?
Okay, thank you, Mr. Banofsky.
Mr. Banofsky, numerous times during the meeting, the applicant has talked about that they're going to use the standard of homeowner clean fill, not commercial clean fill. So that's the standard. They've also talked about not having rebar sticking out of concrete. They've talked about not allowing asphalt in. They also get tested. I think there was a site test that gets done before it gets put on a truck. And then those are all recorded. And they've also just now reiterated for the 40th time that they're going to go ahead and hire, we're going to piggyback on an LP from wetlands to monitor what's going on, because you're 100% correct. It's too big for the town to manage.
And we're going to get quarterly reports.
And we get reports, correct.
But who writes the standard? Does DEEP write a standard for the type of material and how it should be processed? And
no, so
how is it audited and monitored? I know what they're saying. I'm sure somebody, when they provided that material originally, said an awful lot, and somebody accepted an awful lot. And to what standard, and who monitors, and who's the cop on the corner is what I want to know.
Thank you.
This can happen again. It's full of Swiss cheese, full of holes.
Thank you for your comments, Mr. Banofsky.
Mike, we have to get an opinion from the attorney on that waiver, right?
No.
No.
Why not?
No, the
Okay,
waiver,
it says it in our back to the applicant.
waiver's allowed.
Would you like
Done it all the time.
to close the hearing?
The waiver.
Yeah, I'll just.
They're worried about it.
Just
Property.
again,
Shares along.
this has been
And you can't fill.
probably one of the lengthiest application processes that we've been through. I want to thank the
Fill everything
commission
for a giant.
for sticking with us and asking good questions and helping to make our application better. I think over the evolution of the time that my client has owned the property, you know, we've spent a lot of time and effort, and he's invested a considerable amount of money into the community, and is with all the best intentions to make this, to fix a problem, to solve a problem, to right a past wrong that he didn't even commit. And we want to try to get this property back to, you know, to address the previous bad acts and prior violations. I think the wetlands approval is a huge first step for that. We're now before this commission for the second step of that, and we, you know, greatly appreciate your consideration. happy to close the hearing. Thank you very much.
Okay, thank you. By closing this public hearing. Okay, deliberations and determinations. We're going to take a 5-minute recess. Going to continue the regular meeting of the Planning and Zoning Commission of the Town of Monroe, January 6th. It is now, what time is it?
9:34.
9:34. All right, so we're up to deliberations and determinations. We don't have the minutes for us, so.
There was,
Yeah, we have a request, Mr. Chairman, for a correction.
Do we have the
Are you
minutes?
there?
Yes, I'm here.
All right,
We don't even have them.
we don't even have them.
No, but Barbara wants to make an
Go
announcement.
ahead. You can make a request for a change in the minutes.
Right. Yes, I read the minutes online for the December 9th meeting.
Yes.
And there's the correction to be made where I was quoted as saying there's 60% native plants in one of the plans, and it was actually 6, the single digit 6% was the correct number. So, but I did send an email to Rick
Yeah,
with the specifics, so.
Thank you.
just want the commission to note that. We'll make the correction.
All right, thank you.
Vote on it.
You'll have the corrected version?
Yes. Can you send both sets of
Yeah,
minutes next time, please? Thank you.
Yep.
Thank you.
All right.
Thank you, Rick.
So I'd like to begin deliberation on EFP 2021-03 tonight. The rest of the commission is okay to start because it may take some time.
It takes some time.
We may need to direct staff if we need other materials. Are you okay to start deliberations?
yeah, and it's just the seated members.
Yeah, this will just be the seated members. Yes. All right, so
Time on that. I don't want to do it tonight.
you don't want to do it tonight.
I don't
Brian,
want to do it.
I would like to start deliberations tonight.
I'd like to start.
I would like to start as well.
All right, then we'll start.
That's that.
Okay.
yeah, and Mr. Chairman, you want to acknowledge who's seating?
Yes,
Okay.
we have the regular members of the commission are seated for this deliberation. All right, who wants to start? Anybody? In my opinion, we have a pretty simple application, which is why I like it. They basically said they would do everything that we've asked. Again, we have no purview over what has happened in the past on this site, even though it appears to me, not an expert, just a citizen, that there's been an exhaustive study of what's on the site now. If anything was missed, the applicant has stated that they're going to basically dig up the whole site again. While they're doing that, we will have someone there watching them do that and requesting
So
tests.
Well, how are we going to go about that?
We're going to hire, well, inland wetlands and planning and zoning are going to hire a qualified, what is it?
Third-party consultant,
Oh.
LEP consultant.
LEP license.
Yeah, licensed environmental professional, whom the applicant will pay for, to watch them go through all of whatever's been hidden, buried, or whatever there.
And what's intake? What's intake?
They have a pretty good intake protocol. They've already said they're not going to take any asphalt, even though if they're limited to clean fill, they can take large chunks of asphalt, but that gets to be,
But that'll be a condition of
Dicey.
approval.
but yeah, they agreed no asphalt.
They've also agreed to homeowner standards, not commercial standards, which is a little bit more
Anything
stringent.
that's to go below the water table will be native material.
And there's going to be a non-permeable barrier.
And above that, there'll be
The membrane.
a barrier.
No, I have all that. I mean, so you're saying that we're going to have an LP to inspect what they're going to take out of the ground?
Yes.
Yes.
And then what happens going down the years down the road here?
I don't think there's a time limit on how long we can have someone there. No, there is no time limit.
Until it's done. Until it's full.
Right, until
So we're
it's
going to
done.
require that there's an LP.
Well, we're going to have to and staff, and
Right, remember,
we hire
Are you gonna come
somebody
up
and
with-
then you
are
have
you
to
gonna
make.
come
sure-
up
Regs only allow 2-year increments.
What? What's that?
Our permit only allows 2 years.
Right, so it has.
Extensions.
Has to be another
Correct.
2 years. So are you gonna come up with the protocol for what the LP is gonna do? Is it?
Absolutely.
Okay.
As with the Inland Wetlands Commission, staff will be working with the special counsel
Yeah,
on the formulation of this resolution.
right, and when will we have that?
That will be started tomorrow.
Tomorrow, and so.
Well, so you
I mean, basically, okay, I'm with that, but I would like to see that
Oh, absolutely.
during deliberations so that if we have to make any changes, that we could do that. Is
Yeah,
that,
well, before we,
right,
Yeah, you will see a draft.
before we vote, we have to have a draft on this.
Right,
This is
so-
not like your,
right, but I mean, so you're gonna bring us a draft and then if there's something that we have to move around, we're gonna move.
Absolutely.
All right, and so what other conditions are you gonna put on this?
Well, what do you want to put on?
Well, no, I'm saying is, well, first of all,
Our chance.
if there's something in the ground, what happens with a material that's not supposed to be in the ground? That's gonna be removed?
yeah.
So they
Is
dig
it,
something up.
are we gonna
right?
require that that be
Right.
removed?
We have to establish the protocol.
Right, the protocol. So if there's painted brick, it's gotta go out.
Yes.
Because that's
Rebar.
considered rebar.
Yes.
It's gotta go out. And when they bring in the fill, he says that basically the fill's not gonna contain any protruding rebar.
Correct.
Or anything like that. But I really don't understand that if you're gonna bring in concrete that has rebar in it, and they're gonna have to crush it on the site, what happens to the fines and stuff like that? What do we do with that? Does that get removed?
Certain materials have to be.
The what?
Huh?
Fines, what are fines?
Like, when they crush it, particles of cement, besides the big particles that are gonna take out the rebar and fill it with, what do you call it? The little fines and whatever. I don't know if you can bury that, can you, or?
I don't know with certainty, and that's where, when we prepare the scope of services for that third-party professional, I'm
Yeah,
gonna,
that's what I'm saying, and that's the kind of thing that I would want to make sure that that's taken care of, because.
Absolutely.
LEP's purview.
Huh?
That's the LEP's purview.
That's what I'm saying, so, I mean, that's what I'm saying, but that's something.
Right, but Leon, we're gonna set groundwork to this and the LEP's gotta follow that.
That's what I'm saying, so that you're gonna come up with a thing for us, and
And we're gonna approve it.
we're gonna approve it, and
Then the LEP
you can
gets
add or
it,
whatever
and as they-
on the next, you're gonna have that ready for us.
the inland wetlands has to look at the scope of services.
So how
take
long
a little
do you
See, it's got,
It'll take a little bit of
well,
time.
it's gonna take some time.
Yeah, so we can always approve it with the per following the LP, like we're gonna tell, they're gonna
no,
approve
I wanna
tonight. No, it's not gonna get approved tonight.
No, I don't want to
but-
approve it until I see what the LP
It's in
is going to
writing.
do, in writing, right? And so, and what the inland wetlands want to do, because we don't know. I
Well,
mean, there's no way
they're
to-
gonna do what they wanna do. We're not gonna dictate what wetlands does.
No, but you,
But I want to see what they're going to do.
It has to work in conjunction with the two.
What we're going to do.
Yeah.
So,
My question is, it's a 2-year fill permit, correct?
right, they've been asking to extend that at the
So
subcommittee level.
after 2 years, what happens?
Come back in before the commission.
Okay, and then,
Up for review.
and then every 2 years, they have to come back in front of us?
Unless you amend your regulations, it's been on the table to extend it to 5 years.
But even I don't think they're gonna be able to fill it in 5 years.
But they're asking for increments of 5 years instead of 2. At least have that in the regs.
Brett, do you know how long it's going to, well, I don't know if this is part of that, but, and I wanted to ask that question, but then it got, well, how long is it going to take to remove the water out of that hole? Before you can even start doing any of this?
Yeah, I don't know that answer.
Was
gonna take a lot of paper
Last year
towels.
when we went, there wasn't much water in there.
Oh, no, it's filled now.
Oh, I think to the top.
Just to the top.
Now
You
it's
need your
not, no.
scuba gear to go to the
But
bottom.
last time that I was up there wasn't much in there.
Yeah, there's a lot of water.
Might have to
think
borrow,
it's seasonal.
might have to borrow your submarine to get to the bottom.
There's a lot, so, see, I was going to ask that question, but we closed the meeting and I forgot to ask that question. I just wanted to know.
I know,
Because it may take a year for them to get the water out
No,
of there.
Leah, we'll have those,
You don't have an answer?
we'll have those ranges.
You have a calculation? I mean, Scott could pretty much give us a calculation on that, right?
Well, even that professional,
Okay.
has done it before.
All right. All right, so then I guess we gotta wait until the next meeting, right, for you to get a couple of answers on that?
Oh, yeah, absolutely.
Well, let's.
Draft a letter.
Well, you're not gonna draft it, no. There's a lot to
We'll try to get
before the letter of approval.
There's a lot of work involved in this, so.
But there may be something that
How much? What,
LP would want us to put in there
next meeting?
that we don't have in there either, so I
The
mean.
next meeting, you'll have a better handle.
We're not gonna approve it
How?
after an LP's hired. We have to, they're not gonna hire an
No, but
LP
they're gonna
unless
put
it's
the scope
approved.
of what the LP.
Yeah, but the
He's gonna
LP
reach out to council.
Yeah, the scope of services starts tomorrow.
Right, to see what
Yeah.
we should require. And then I think we have to put that into.
Yeah, absolutely. Into your resolution, right?
So then we'll draft a thing at that point. I would believe that's the best way to do it because I don't want to say we'll draft an approval or start drafting approval without me knowing what is going to be.
There's going to be two parts in the scope of services to address inland wetlands.
Right.
And then the P and Z.
Right, okay.
And we're still good with the 2 years on the permit and then having them come back for an
An
extension?
extension, yeah.
We don't have a choice, right?
No.
And how many extensions are they allowed?
You're
We
allowed,
know how many extensions they're allowed?
as many as to get the project completed.
So it basically, if the project is not going,
Yeah, well, you need to address it. At the subcommittee, you need to look at the whole thing
Yeah,
comprehensively.
we're gonna have to look at that in this.
Absolutely.
but so,
Mike.
so in every 2 years, we're going to look at it and see where we stand and then we go from there.
Right.
I mean, we're not mandated
2
to
years, 2 years.
give them
They may run out
an
of,
extension, are we, or no?
they may do it.
No, but you gotta have reason. You gotta have a justifiable reason to say no.
To say that we're not going to continue. No, that's,
If things aren't going as planned.
Hey, just so you know, when I was in North Branford for the Tilcon Quarry, and I know O&G has this in Southbury and Woodbury, every 2 years, they would go before the land use boards and give updates on where they're at and where they're going. I mean, this is not exactly the same thing, because this isn't a permitted quarry. But we're going to be looking at some of those standards too. So I'll be bringing that into.
Are we gonna have, I know we're gonna have a report from the LEP, but what about Mr. Carp and Mr. Sully? Do they have to come in front of us every so often?
Well, Mr. Carp indicated tonight he'd be willing to give you updates whenever,
So we'll have to put that in the condition of approval also?
if that's something that you would like, absolutely.
I don't know, it's up to you guys.
And the other question I have to ask, what happens if something happens there that is like, if they bring in for some reason
So
contaminated
you bring that up, that's a contingency.
contingency that the permit is null then at that point? Is that what we put in there?
Yeah, and that's where I'm going to be relying on special counsel.
Right, okay.
Absolutely.
That's probably that's what I need you to do is get that written up first so we can look at that.
There's a lot of components going into that.
Right, no, that's what I'm saying. And this is a big undertaking. And not that it was Mr. Carp's fault or anything like that, but I'm saying that this is a big undertaking for this town to make sure that this is done right.
Commissioner's going to get this right.
Okay.
So Leon, if all these conditions are met, are you comfortable in approval on this? You've been
I have to
critical.
see, I've been critical on, the reason being is I don't want it to turn into a recycling facility. Okay, and that's why I stated what I stated. And I have big concerns over that because it can turn into be a recycling facility. And it's happened on other places where now that's people with their clean fill regulations, they have changed them. And they have changed them that where you can't collect money for bringing material in. And the reason that is because things could be moved around. You understand what I'm saying?
But it's not.
Yeah, I mean, so it's like, you know, if you look at different standards for other states that they've changed their standards over that. I've done a lot of research on this because I'm very concerned because it's in a GAA water site. And that's my main concern. My main concern is that if we contaminate the water over there, we have big problems. And it's not just, you know, with the intervener, it's the whole town. And it's, you know, because that feeds like.
The area is very vulnerable right now.
Huh?
The area is very vulnerable.
Very vulnerable. It is. And the thing is if we don't get it right and it's not done right, and like I said before, this approval goes with the property. If Mr. Carp for some reason sells it or whatever, we have to deal with the next person. And that happens.
You also
all the
have to
time.
deal with the conditions.
Right, is exactly right.
The problem is if we leave it as so, it's actually worse than
then, well, no, it's like everything else. I mean, it's already, it's filled already to the top. So it's not all stormwater. It's definitely a lot of groundwater in there. And so my concern is putting stuff into the groundwater. I have very concerned about putting stuff in the groundwater. And it's not like it's just like, I've done a lot of research on it because of, well, first of all, it got to a point that it shouldn't have got to. And it's there now. Now we have to deal with
There's
it.
nothing we can do with it.
Right. And so I'm very concerned about what could happen to the water. That's, and I think basically we all should be concerned. We all are.
I think the other concern is that right now we do have an applicant who has agreed and has been very willing to work with us and go a little above and beyond, but because of what had happened in the property in the past, we've held them to a higher standard. We're not punishing them, but we're doing the right thing.
Like I said
I think we're all in agreement there.
Right. Like I said.
Hold on, let me just finish the thought. But my concern is if this property transfers hands without this approval, without this in place, somebody else can come in that is not willing to work with this committee at all. And we could have a serious problem because we have exposed groundwater right now that we need to cover up and protect. And this seems like a good way to do that. And in 2 years, they have to come in front of us again. So if they do sell the property and somebody takes it, in 2 years, they have to come back for another approval of this. Or we could say no, and then it stops. If it becomes a recycling plant in a year and a half, in 2 years, it's coming back in front of us and we're going to be very aware of that.
I know, but we have coverage on that kind of stuff. We have an LEP that they're going to hire that's going to constantly monitor it. And then we also have a zoning enforcement officer that can, Monroe's not that big. I'm sure he could swing by every once in a while. And if
Well,
you're turning
I mean,
it into a recycling facility,
I think Leon's going to swing by once in a while.
Leon may move his mechanic shop
That's
there.
the real thing. If something bad's going on down there, you're going to find out. I'm sure Mr. Metropolis is going to let the town know. I'm sure there's going to be a lot of eyes on this. And I'm sure the owner is very aware of that.
But the thing is like I said before, is it goes with the property, no matter who owns it.
Mm-hmm.
And so.
For 2 years.
No.
Right?
Not necessarily.
This approval is just for 2 years.
No, the fill part of it.
Yeah, and that's all we're approving. That's got to be very clear. That's all we're approving today, or maybe approving. There's no building going there. There's nothing else.
Nothing else going there but
This is only a fill permit. There is nothing, this could get filled and this commission could never approve a building on the property. I'm sure the applicant wouldn't want that, but that's a possibility. I mean, this is to fill. Yes, there's going to probably be a plan in front of us and we're aware of that. But at the end of the day,
they're nowhere near a plan.
That might not ever get approved.
They're nowhere near putting a plan.
This is to fix the wetlands.
No, this is probably.
Right, so
this has got to be at least an 8-year project. That's what I'm saying.
And we'll address those. And Mr. Chairman, I have another statement I want to make. The Southwestern Conservation District has also stated they are here to assist staff and the commission on this resolution. So we'll be using their expertise as well, too. The inland wetlands use the Southwestern Conservation District. So we have
Can I get some input from them?
Absolutely.
All right, so.
Mr. Chris Sullivan has indicated that their department, their facility will be assisting us.
Here's something I don't want, though. I don't want this to be, now we're prolonging to get information here and there and there and there and there. This can't take another year. At least I can't take it.
Well, we closed it, so it has to be done. It's
We
closed.
have statutory.
I understand, but what I'm saying is it can't take Rick to work with wetlands and us and the Southwest Conservation District. And then in 6-8 months, we finally get an approval from
We're
us.
not here to hold up the that.
And Rick, now that we closed it, don't we legally have to?
We have timeframes.
What's the time frame we have?
65 days.
65
days. And extensions are permitted, but it's got to be authorized by the applicant.
Right, but 65 days we have.
That's right. You got to move forward.
Time.
Okay, good.
So that's fine. So then you're going to work on.
I just want to advise you, we have professional assistance.
Okay, that's fine.
4 meetings.
So you'll have
how I
something
look at
for
it.
us at the next meeting? Well, maybe not.
Well, I'm going to have an outline.
All right,
I'm
yeah.
going to have an outline of,
That would be good for me.
within the timeframe of the state statute.
Okay.
And Mr. Chairman, too, Special Counsel Vin Marino, after you conclude, wants to talk about some other zoning related issues.
Tonight.
Oh, yeah. It wasn't on for this?
No.
Oh, boy.
Well, let's go on to that then.
Well, in many ways, you don't want to be too specific in your,
Yeah, like they were very vague because now it allows them to dictate, right?
yeah, if you want to keep it a little general.
No, I understand. That's why he is going to talk to council and talk to, who else you said was going to get involved with it?
Southwestern Conservation District.
So let's get that information and then we'll go from there. I think that's probably our best bet.
Yeah, I will have an outline.
And figure out where we want to go. I mean, not, like you said, let's not get too specific, but let's not go.
Specific.
Let's get something on that we all agree on and that we feel comfortable with, is the way I look at it. I
And if
think.
you're too specific and something comes up.
No, that's what I'm
there's no way
saying.
of addressing
Yeah,
it.
That's what
because
I'm
if you
saying. So I don't
reread
wanna-
what they wrote.
Right,
is
I don't want to
very-
go too crazy, but he's going to work on that.
Yeah, but once we have an outline, then we can.
That's what I'm saying, we can
Plug
go
and
back
play
and
and then move it on. And we
play and
have
we can figure it out.
65 days only.
65 days, right.
Only.
You're allowed extensions if the applicant authorizes them.
Right, okay.
But we're not going to need that.
We better not need an extension.
Let's see what Ben has to say.
Is there any other ideas, anything else you'd like to see in as conditions of approval?
You guys got anything else?
No, I think we can,
Nothing else right now. Let's-
Once we have an outline.
yeah, I guess, and
Let's get an outline.
start getting us some more info and
Next.
we'll
Finish it up.
continue with deliberations at the next.
Right.
Okie dokie.
Now, let's see what Ben wants.
Is this a?
Leon wants to see what Vin
All right,
wants.
so
I've only heard it like 30 times. Like
Vin wants to see what Vin wants. No, Mr. Chairman, and Commissioners, I just wanted to update you on changes in the law that you should consider holding a special meeting or putting this on an agenda within the next month or two. There are some deadlines that you need to be aware of. For example, outdoor dining is as of April 1. And if you want to address your regulations with respect to regulating outdoor dining, you may want to jump on that. If you want to opt out of, the parking limitations with respect to dwelling units, with accessory apartments, or with temporary health care structures, there's a process you need to go through, and then it has to be referred to town council for final approval. So these are things that, not for purposes of conversation tonight, but I just wanted to highlight to you that I would recommend, putting this on your agenda within the next meeting or two, so that I could update you on your options and things that you should be aware of. Such as beginning in January of 23, you all have to start taking 4 hours a year of educational courses. Sorry, and 1 hour of which has to be affordable housing related. So, I just want to make sure you're updated on the changes in the law and how it could affect your regulations.
Vin, that's a state requirement that we have to do that right now?
Yes, it's a Public Act 2129 put a lot of changes to the zoning and land use laws, and your zoning enforcement officer has to be certified. I believe that begins January 1 of 2023 as well. And they haven't defined exactly how you all need to be, quote unquote, continue to take your continuing education classes. We may be able to do that in-house for you. So I'm sure over the next year, they're going to put out guidelines on that. But again, for the commission, there are a bunch of changes that have come out through Public Act 2129 and 21-2. And I just want to make sure you're aware of it, so you don't get blindsided over the next year or so.
No, that sounds good to me, yeah. So,
Well, we'll have to address that probably in our next subcommittee.
do you want to come to a subcommittee meeting?
No, I
or
think it's
do you wanna-
I can forward to you. I put together a kind of, for all the towns I represent, like an action item list.
Yeah.
And I could forward it to you. I could attend a meeting and discuss it with your subcommittee, whatever your pleasure.
That'd be great. That'd be great.
Yes, thank you, Vin.
Thank you, man.
I will forward it to Rick and Rick can get it to the appropriate.
All right.
Okay.
Okay, thank you.
So do we have any other correspondence?
No, Mr. Chairman.
All right, we don't have a time or a date for the next subcommittee meeting.
No, we do. We're meeting on Tuesday, the 25th,
Can't be the 23rd, that's a Sunday.
5:30.
Tuesday?
We had some, right, Tuesday,
Yeah, 25th.
Tuesday, 5:30. We're going over a variety of things, the draft open space plan by the Conservation Commission as a supplement to the POCD and some other items. 5:30, yep,
Are you bringing pizza?
yes.
Pizza, I'm starving. 5:30 is my dinner time.
January 25th.
Tuesday, the 25th.
So I shouldn't eat dinner?
No, Rick cut pizza.
Got everything? Okay. Oh, if I come.
That was what
So
that.
you'll have Vin's bullet list for that as well, right? Okay. All right, moving along. I have
Meeting
no
adjourned?
report. No, commissioner reports. Any commissioner reports tonight? Anything you'd like to?
Nothing.
Bring up, anything on your
I
mind?
noticed the McDonald's parking lot seems to be
Moving
worse.
along.
No,
No, I was there today. I was there tonight.
past few times I've driven by, it seems to be, either no one's going there anymore or,
Maybe, I don't know.
yeah, it seems to be moving.
Don't forget. it's-
Okay, land use staff report. Do we have a report
Yeah,
tonight?
that'll be brought up on the 20th.
Well, you know, like, it was closed for so long, so people were like, oh, man, it's really.
Okay, it's on,
We're going.
Chair will entertain a motion to adjourn.
Motion to adjourn.
Second.
Second.
All those in favor?
Oh my goodness, it's 10 o'clock.
10:01.
10:01.